2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. Now recognize the gentleman from Texas. Gentleman from Texas to lead us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Pursuant to notice, I call up the report recommending that the House of Representatives cite Robert Hunter Biden for contempt of Congress and move that the committee report it to the House. The clerk will report the report.
Resolution recommending that the House of Representatives find Robert Hunter Biden in contempt of Congress for refusal to comply.
Without objection, the report will be considered as read and open for amendment at any point. The chair now recognizes himself for an opening statement. Who is the big guy? We all know, we all think we know, seems pretty common sense, but who is it? That's one of the questions we'd want to ask Hunter Biden. What was the business? What was the service that the Bidens provided? What was the president's son doing to earn millions of dollars from foreign entities in jobs he wasn't qualified to have? And what did the president know about his family's foreign financial entanglements? These are just some of the questions that Congress needs answers to as part of our impeachment inquiry. To get those answers, the Oversight Committee and the Judiciary Committee issued subpoenas to Mr. Biden, compelling him to appear for a joint deposition on December 13th. Mr. Biden came to the Capitol on December 13th, but did not come to the committees for that deposition. Instead, he staged a press conference in front of the Capitol. This flagrant disregard for Congress's constitutional oversight role clearly merits a citation of contempt. It's an open and shut case. Mr. Biden was issued an authorized subpoena, and without asserting any valid privilege, frankly, I don't think he asserted any privilege, valid or not, he didn't show up to testify. This is a vote to protect our institution. Hunter Biden is a critical witness in the House's official impeachment inquiry and uniquely possesses knowledge about what role the president may have played in leveraging policy-making decisions to enrich the Biden family. Of course, the American people deserve to hear directly from Hunter Biden about these facts. And we fully intend for Mr. Biden to testify before the public, but as is often the practice across committees under Republicans and Democrats, he should first sit for a deposition so that the American people get a full airing of the facts. Here's just a few things we need Hunter Biden to shed more light on. During a transcribed interview with the Oversight Committee, Devin Archer, longtime associate of Mr. Biden, described how President Biden was, quote, the brand, and was used to send, quote, signals of power, access, and influence to enrich the Biden family from foreign sources while he served as vice president. Mr. Archer testified that Mr. Biden placed his father on speakerphone during meetings with business associates approximately 20 times. We know one of those calls was made on December 4th, 2015. On that date, while Hunter Biden was in Dubai with Burisma executives Mr. Zolochevsky and Mr. Pizarski, they asked Hunter Biden to help alleviate the pressure they were under from the prosecutor in Ukraine. According to Mr. Archer, after that request was made, Hunter Biden, quote, called his dad. We know that a year after Hunter Biden was put on the board of Burisma, Vice President Biden attended a dinner at Cafe Milano on April 16th, 2015 with Mr. Pizarski and Hunter Biden and Devin Archer. Devin Archer, who was also on this Ukrainian energy company's board. What then Vice President Biden did with Burisma is the blueprint for how this whole influence peddling scheme worked. There are 4 fundamental facts about the Biden's involvement with this company. Fact number 1, Hunter Biden was put on the board of Burisma's board of directors of Burisma and made millions of dollars. Fact number 2, Hunter Biden was not qualified to be on the board. Not my words. He said so himself in an interview on ABC News. Fact number 3, Burisma executives asked Hunter Biden to help alleviate the pressure they were under from the prosecutor in Ukraine. Fact number 4, Vice President Biden used his official position to hold up American tax dollars going to Ukraine until that pressure was off Burisma. He conditioned the release of funds on the firing of the prosecutor who was applying the pressure to the company that his son sat on the board of. And these facts are corroborated with the confidential human source who told the FBI and was recorded in the 1023 form. In fact, the prosecutor, Victor Shokin, is mentioned 8 times by the confidential human source in that 1023 form. That same form, by the way, that Director Wray tried to prevent Congress from seeing. The confidential human source said Burisma hired Hunter Biden to protect us through his dad from all kinds of problems. In addition to all that, the House Ways and Means Committee uncovered a threatening 2017 message from Mr. Biden to a Chinese business executive related to a business deal in which Mr. Biden wrote, quote, "I'm sitting here with my father, and we would like to understand why the commitment made has not been fulfilled." 9 days later, Mr. Biden invoked his father in that threatening message. A company affiliated with that business wired $5 million to a company jointly established by Mr. Biden. The same day, Mr. Biden transferred $400,000 from this joint venture to his personal company, and it appears now that President Biden ultimately received $40,000 of those proceeds. Rather than come before us and answer questions about these and other concurring instances of the Biden family trading cash for influence, Hunter Biden held a press conference a few hundred yards away from here, press conference where he said, "I'm happy to answer questions in public," but when he finished his statement, he abruptly left, taking no questions from the press. We have no choice but to hold Mr. Biden in contempt, and I would encourage a yes vote. Would now yield to the ranking member for an opening statement.
Thank you, Mr. Chairman. After a year like 2023, a year marked in the House of Representatives by Republican infighting, the ouster of a speaker, and growing legal peril for the former president, you would think that House Republicans would want to turn the page and try their hand at some actual legislating. It is unfortunate, but not surprising, that the MAGA wing of the Republican Party seems impervious to learning from its recent past. They seem committed to the same political stunts that have, by any measure, made their majority the least productive Congress in modern history. Their own members acknowledge how little they have accomplished. So here we are again, just days before a government shutdown, with war raging in Gaza and Ukraine, with Americans at home facing real problems that require our attention. House Republicans want us to know that their highest priority is, once again, Hunter Biden. And why are they chasing Hunter Biden? They are certainly not chasing him because they have uncovered evidence of any wrongdoing by President Biden or the Biden administration. Over the course of this investigation, such as it is, we have collected thousands of pages of documents and spoken to more than a dozen witnesses. One of those witnesses was Special Counsel David Weiss, who took the unprecedented step of sitting for an interview in the middle of an ongoing criminal investigation. After all of that work, House Republicans have found not a shred of evidence to suggest that President Biden was anything other than a supportive father to his son, or that his administration in any way exerted political pressure on the investigation into Hunter Biden's conduct. True, every few days, House Republicans hold up some copy of a bank record or excerpt from a transcript and claim that at long last they have finally found the smoking gun. But like clockwork, often within minutes, each new claim is thoroughly debunked. Then a few days pass and they do it again, and round we go. If Chairman Jordan and Chairman Comer were really interested in letting the American people see just how little they have found to support their accusations, they would release the transcripts of our interviews in full, instead of cherry-picking words out of context to mislead the public. For that matter, if House Republicans were genuinely interested in hearing testimony from Hunter Biden, they would have honored their initial offer to have Mr. Biden testify in public. I understand Mr. Biden is still willing to appear at a public hearing at the time and place of the chairman's choosing. I hear my Republican colleagues when they say that a congressional subpoena must be honored exactly as it is written. But you will forgive me if their newfound care for the institution sounds a little thin. This whole investigation is premised on the claim that the president is somehow profiting from his office. Let's set aside for the moment the fact that this claim is entirely evidence-free. No, I have trouble taking this new interest in foreign corruption seriously because these same Republicans did nothing while President Trump took millions from foreign interests in violation of the Emoluments Clause to the Constitution. Thanks to our Democratic colleagues on the Oversight Committee, we now know that Trump received at least $7.8 million from 20 foreign governments, including the governments of China, Saudi Arabia, and the United Arab Emirates, while he was in office and while he was negotiating with those same governments. Unless it is to defend the former president, House Republicans are steadfastly silent when it comes to Donald Trump's actual, open, documented corruption. But they need to hold Hunter Biden in contempt because he once paid his father $1,400 for a 2018 Ford Raptor? Please. Republicans say that this contempt vote is necessary because it's important for the committee to defend its prerogatives. Again, this new concern for the rights and privileges of the Judiciary Committee seems wholly insincere. As we speak, the Homeland Security Committee is holding an impeachment hearing. By all reports, they intend to bypass judiciary altogether to bring articles of impeachment to the floor. The Constitution gives the sole power of impeachment to the House of Representatives, and for the whole of modern history, the House has delegated that authority to this committee, until today. I do not know whether the decision to cede our jurisdiction to House Homeland was made with Chairman Jordan's blessing or over his objection, but either way, it is a terrible precedent. The decision has permanently diminished us. It weakens future chairmen of both parties. And you have ceded this ground, apparently, so that you have time to bully the president's son. And let us not forget the elephant in the room. House Republicans say that we must force Hunter Biden to comply with this subpoena. But they said nothing when Attorney General Barr and White House counsel Don McGahn stonewalled this committee. They cheered the former president on when he vowed never to comply with any of our requests. And the chairman himself blew off a valid subpoena for his testimony from the January 6th Select Committee. What chutzpah, what gall. Whatever technical excuses you made for yourself at the time, Mr. Chairman, I assure you, Hunter Biden is the same. This committee has an obligation to work in good faith towards an accommodation with Hunter Biden, and to my knowledge, there is no precedent for holding a person in contempt who remains willing to testify. You may score points with the MAGA base by forcing this vote today, but you threaten to do real damage to our ability to secure evidence and testimony in the future. As with so much of this Republican Congress, there is a reasonable deal to be had here. House Republicans just refuse to take it. This contempt report is poorly timed, riddled with factual errors, and rife with hypocrisy. It has nothing to do with solving real problems for real people. I urge my colleagues to oppose it, and I hold out hope that this committee will return to more pressing work someday soon. I yield back.
Gentleman yields back. The chair now recognizes himself for the purpose of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purpose of the amendment. The chair now recognizes himself to explain the amendment. This amendment makes a small grammatical change on page 17 of the report. It does not affect the substance of the report. I yield back. Who seeks recognition?
Move to strike the last word.
Gentleman from California, Mr. Swallow is recognized. Then I'll come to you, I think. Fitz.
Mr. Chairman, is this a joke? No, seriously, is this hearing a joke? This is a committee that now cares about subpoena compliance, and we're going to hold somebody in contempt for subpoena compliance? That's really interesting because, to me, it seems like you believe we all had our memories wiped 608 days ago when you failed to honor your own subpoena. You see, on May 31, 2022, as the January 6th committee was investigating the greatest crime ever committed in America with the most arrests, the most convictions, a crime against our Congress, our Constitution, our democracy, all they wanted was for you and a few of your colleagues to cooperate, to provide any information you had. And what you all did for 608 days and counting, you didn't show up. And you want us to take this proceeding seriously, where you have an issue with somebody else's compliance with a subpoena, somebody who actually is willing to come forward publicly, something you were not willing to do, something you and Mr. McCarthy and others who were asked to testify were not willing to do. So seriously, is this a joke? If it's a joke, great. This whole Congress has been a joke, so it would be in line and on brand with what has been taking place. But I have to ask, like, how dumb do you think the American people are that you would seek to hold someone in contempt when you are 608 days, 15 hours, 21 minutes, and 47 seconds out of compliance of your own subpoena? I don't know, Mr. Chairman, if it is your practice to look the other way when crimes are committed, but it's not my practice, and it's not my colleagues' practice. So what is this really all about? It's about this chairman, Speaker Johnson, and the MAGA majority acting as Insurrection LLP, creating the biggest law firm in Washington, D.C., to work every single day in this building on behalf of just one client, the former president, Donald Trump, and to carry out his petty grievances every single day. Okay, that's great. You won the majority. It's your prerogative. But the cost to the American people is we aren't doing a single thing in this committee to address gun violence, the mass shootings that occurred in the 3 weeks that we were gone. We haven't done anything to address what's going on at the border, a president who's willing to negotiate and find ways to better secure it. We're not doing anything to bring down the cost of health care and take on the pocketbook, financial breathing room issues that the American people care about. Okay, let's talk about Hunter. Mr. Comer and Mr. Jordan said, we want Hunter Biden to come in. Hunter Biden said, okay, I will come in. Mr. Comer said 2 different times, we will take his testimony publicly or we will take it privately. We will take it publicly or we will take it privately. Hunter Biden said, okay, let's do it publicly. I don't trust you all to take it privately because you haven't released the depositions that you have taken privately. Can't blame him for that. He wants to come in and testify publicly. You won't take yes for an answer, and so then you move it to let's take it privately. I think you want to take it privately because you have nothing. I think you want to take it privately because you don't want to see Marjorie Taylor Greene display the non-consensual nudes from Hunter's laptop again. I think that's why you want to take it privately. But he comes in anyway. You won't take yes for an answer. And let me just break some news for you, Mr. Chairman. Just down the hallway, Hunter Biden is sitting in the Oversight Committee. He's ready to testify publicly, it appears. So let me just challenge you one more time. If you're so eager to take his testimony publicly, I move that we adjourn right now and take his public testimony and bring him in here right now.
Is the gentleman making a motion?
Yes?
Questions on the motion to adjourn?
Question is on the motion to adjourn.
Those in favor say aye.
Those in favor will say aye.
Aye.
Those opposed, no.
No.
Opinion of the
Recorded
chair,
vote.
the noes have it.
Recorded
Gentleman's
vote.
requested a recorded vote. Clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? No. Mr. Issa votes no. Mr. Buck? Mr. Gates? Mr. Gates votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Massey? No. Mr. Massey votes no. Mr. Roy? Mr. Bishop? Ms. Spartz? Ms. Spartz votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew?
No.
Mr. Van Drew votes no. Mr. Nels?
No.
Mr. Nels votes no. Mr. Moore? Mr. Kiley? No. Mr. Kiley votes no. Ms. Hageman? No. Ms. Hageman votes no. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? No. Mr. Fry votes no. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye.
What's the number? Gentlelady from Texas?
Ms. Escobar votes yes.
Gentleman from North Dakota?
Mr. Armstrong votes no.
All members voted. Clerk will tally and report.
Mr. Chairman, there are 12 ayes and 15 noes.
The motion to adjourn is not agreed to. Gentleman from California yields back? He yielded back. Oh, I'm sorry. The chair
I yield
recommend- Chair recommends myself. I would just say this. Why didn't they hold me in contempt?
I move to
Why
hold
didn't the committee hold me in contempt? They certainly could have. It was a completely partisan
moved.
Would the
committee.
gentleman yield? And I'll explain why.
No. In a second, I want to finish my my time here. It was a completely partisan committee. Why not do it? I mean, the idea that if you could have held the future Speaker of the House, the future Chairman of the Judiciary Committee, the Freedom in contempt, why didn't you do it? I think they didn't do it because they knew it was bogus. They knew that
gentleman yield?
the speech or debate clause would not allow them to compel someone member of Congress to come testify. But by the way, I never said I wouldn't testify. I wrote an 11-page letter to the chairman, to Chairman Thompson. I'm still waiting on a response where I spelled out all the concerns we had with this committee, all the things we had caught them saying that were not accurate.
Will the gentleman yield?
No, it's my 5 minutes. I'll yield and we'll have plenty of time. I'm sure there'll be a debate. They never made a record of it. We made a record of Hunter Biden not showing last week. We actually had a court reporter there. We made a record of him not showing up for his deposition when he was over doing a press conference on the Capitol, outside the Capitol. So I think the Democrats know how ridiculous that was. And with that, I would yield to the gentleman from California.
I think the chairman, my colleague, Mr. Swalwell, who participated in that contempt by asking for and holding that press conference for Hunter Biden, knows very well the history of this committee. This committee has always enforced our legitimate subpoenas. When I was an early member of this committee, then Chairman Conyers, John Conyers, held the Bush White House in contempt, took it all the way through, and Judge Bates, an appointee of President George W. Bush, held that, in fact, you must come before this committee. There's no question that after we go through this process of contempt, a floor vote, and ultimately a court challenge, that Hunter Biden will be ordered to come here. He'll be ordered to come here for the same reason that Harriet Miers was ordered to show up when George W. Bush, within his rights, fired 9 of his own appointees, and this committee had questions as to the motive. That's a sad piece of history for some of us, because some of us were not supportive of that contempt motion. But in retrospect, this committee has always asserted its rights when those rights were violated, and they were violated by Hunter Biden. And they are still to this day being violated, except, as Congressman Swalwell just made very clear, Hunter Biden is thumbing his nose not once during the day of his his subpoena. But even today, while he sits over in a hearing, not testifying, simply sort of going, nah, 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 I've got you. Well, you know what? This is too serious a committee. This is not a joke, Mr. Swalwell. This is the most significant committee of the Congress because we take seriously people coming before it. We take serious the threat of impeachment. And in fact, we are the committee that when impeachment does happen, it has to come through. So quite frankly, this is not a joke. I look forward to us marking this up, moving it out, having a vote on it, and ultimately getting Hunter Biden to answer questions about his undoubted selling of the Vice President of the United States, of his last name, selling it around the world to countries including Russia, Ukraine, China, and others. I don't think there's any question that the evidence is clear. Now the question is, will he come forward or will he take the fifth? And I'm going to predict, Mr. Chairman, that when it's all said and done, Hunter Biden will simply take the fifth. He's just trying to delay that as long as he can. And if he can, he'd like to have it like a few others have over the years, where he makes a speech about his innocence and then takes the fifth. You and I were there for that when the IRS did that. I believe we're going to see that. But whether it occurs publicly or privately does make a difference. If he's just going to take the fifth, which I suspect he ultimately will, then he should do it behind closed doors and not have a public stage to do it. And Mr. Swalwell, you can chastise the chairman, but subpoenaing members of Congress is something we do not do under speech and debate for good and valid reason. It's the reason that you're not subpoenaed here today in this contempt after what you did with Hunter Biden. I yield back.
Mr. Chairman, I have an amendment at the desk.
The gentleman from California is recognized as the gentleman.
Gentleman has an amendment at the desk.
Amendment at the desk. The clerk will report.
Amendment to the amendment in the nature of a substitute.
Reserve, point of order.
Report for the resolution recommending that the House of Representatives find Robert Hunter Biden in contempt of Congress for refusal to comply with the subpoena duly issued.
Without objection, the amendment we consider is read. The gentleman from California is recognized to explain his amendment.
Today, Chairman Jim Jordan has convened a hearing to take action against someone he says ignored a congressional subpoena. Today, Jim Jordan says that failure of this witness to appear was, quote, in blatant disregard of Congress's oversight role. Today, Jim Jordan says we must respond because, quote, he didn't show up to testify, unquote. And I say, bravo. Jim Jordan is finally ready to take action against Jim Jordan. This amendment would amend the contempt resolution and provide the form of the resolution that the Committee on the Judiciary would recommend to the House of Representatives, citing Robert Hunter Biden and Jim Jordan for contempt of Congress, pursuant to this report as follows. Resolved that Robert Hunter Biden and Jim Jordan shall be found in contempt of Congress for failure to comply with a congressional subpoena. Now, I know the chairman wouldn't want an ordinary citizen to be treated differently than a member of Congress. So let's run through some of the facts. On December 22nd, the Select Committee of Congress investigating a violent attack on the Capitol requested that Jim Jordan provide information for the committee's investigation, knowing that Mr. Jordan was a percipient witness to some of these events, had conversations with those involved in planning efforts to overturn the election. On January 9th, Jordan responded to the Select Committee's request with a letter refusing to comply. On May 12th of 2022, the Select Committee subpoenaed Jim Jordan, along with others, for deposition testimony as part of our investigation into the January 6th attack. On May 27th, Jordan failed to appear for his scheduled deposition before the Committee of Congress. On May 31st, the Select Committee indicated that Representative Jordan should appear for deposition testimony no later than June 11th. But Representative Jordan once again did not appear before the Select Committee on or before the June 11th, 2022 deadline, and he was referred to the Committee on Ethics. And so today we can remedy this situation. We can show some consistency if we're going to hold Hunter Biden in contempt for not showing up before the committee. when he's offered to come and testify publicly. But if we're going to hold him in contempt for that, then surely we would hold Jim Jordan in contempt for his failure to appear before Congress. So this amendment would simply add Jim Jordan's failure to appear before Congress, his blatant disregard of congressional oversight, to use the words of the chairman himself, and remedy this by including him in the contempt report, referring to prosecution for potential prosecution for contempt of Congress. And I would urge everyone's support. And with that, I'm happy to yield to any of my colleagues. I yield to Mr. Nadler.
Thank you. Let me just say that I will vote for this amendment with misgivings. I will vote for it because it improves the resolution. I will vote for it with misgivings because it cites Hunter Biden for contempt, while in fact Hunter Biden has repeatedly stated his willingness to come before this committee in open session and to come before the Oversight Committee in open session, and he's there right now. So he should not be cited for contempt because he's willing to testify. He's volunteered repeatedly to testify before either or both committees. I will vote for the amendment nonetheless because it does improve this terrible underlying resolution. And I thank you. I yield back.
Would the gentleman yield?
I'd be happy to yield.
I will also support this with some misgivings. The committee, when the chairman refused to comply with our subpoena, the January 6th subpoena, did have a discussion about enforcement. And by the way, the speech or debate clause does not apply because the Constitution says that members may not be called to account in any other body. And in fact, it isn't another body, it's the House of Representatives, so speech or debate does not protect. But in our discussions, we had a concern about separation of powers and referring the members of Congress to another branch of government for enforcement of our subpoena. That is why we sent this to the Ethics Committee. However, given that the chairman apparently is critical of that suggestion, I will support Mr. Schiff's amendment. I would just like to note, if I may also, that there has been some considerable confusion about the committee's position on public testimony. No potential witness insisted to the committee that they testify in public. Had they done so, we would have been forced to allow that to occur. Public as composed to formal hearings in the Cannon office building. Mr. Bannon never agreed
Point of order, Mr. Chairman.
to testify and
Point of order, Mr.
unfortunately
Chairman.
refused to send documents. So that as a precedent is simply inappropriate. And I yield back to the gentleman from California with
Time
thanks.
has expired. Does the gentleman insist on his point of order?
I do, Mr. Chairman.
Gentleman is recognized.
For a number of reasons, Rule 10 confers on the Committee on Ethics exclusive jurisdiction over members of Congress. Additionally, Rule 16, Clause 7, puts this outside of our jurisdiction. And, Mr. Chairman, in an analog way, it is clear that the January 6th committee expired at the end of the last Congress without ever making any sort of a motion or referral. In fact, they seem to have ignored your responses. In ignoring your responses, they very clearly accepted your non-appearance. And although they would like to rewrite history now, they had an opportunity to take action. They did not take action. So for those rules of the Congress, in addition to the common sense that there is no subpoena in place, because subpoenas, as you know, expire at the end of a Congress, as did the January 6th committee, I would continue to hold this as out of order.
The gentleman's,
Chairman,
the gentleman from the ranking member is recognized.
what Mr. Issa said is a very interesting statement, but I don't understand what his point of order is. What is he objecting to?
Yes, it's beyond the scope and purpose of today's resolution. In other words, you can't amend it to add under Rule 16, Clause 7.
Gentlemen,
Oh, you're making a point of order against the amendment?
yep, the gentleman's amendment does not satisfy, the gentleman from California's amendment does not satisfy the subject matter and fundamental purpose test, therefore is not germane and is out of order. Who seeks recognition?
Mr. Chairman,
You appeal the-
on that point, before the chair rules,
I've already ruled, but the
I would appeal the ruling of the chair.
Gentleman appeals the ruling.
gentleman is recognized to appeal the ruling of the chair. Gentleman appeals the ruling of the chair. We'll call the roll.
The motion is not beyond the scope of this report because.
You've already made a motion to appeal the ruling of the chair because I already ruled, so the clerk will call the roll on appealing.
Mr. Chairman, I move the table.
Gentleman moves to table. The
Motion
motion,
is not debatable. Those in favor?
motion is not debatable. The question is on the motion to table. All those in favor say aye.
Aye.
Those opposed?
No.
Opinion of the chair is the ayes have it.
Mr. Chairman, we request a recorded vote.
Gentleman from California requests a recorded vote. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck? Mr. Gates? Mr. Gates votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Mr. Bishop votes aye. Ms. Sparks? Ms. Sparks votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes yes. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Gooden? Mr. Gooden votes yes. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes aye. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? No. Mr. Johnson votes no. Mr. Schiff?
No.
Mr. Schiff votes no. Mr. Swalwell? No. Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Ms. Scanlon? Mr. Neguse? No. Mr. Neguse votes no. Ms. McBath? Ms. Dean? Ms. Dean votes no. Ms. Escobar? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy? Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Chairman, there are 18 ayes and 13.
The motion to table the ruling of the appeal of the chair is agreed to. And who seeks
Mr. Chairman,
recognition?
I have unanimous consent requests.
Gentleman from Kentucky is recognized for a UC.
I asked unanimous consent to enter into the record an article titled, "During January 6th hearing, Schiff doctored text messages between Mark Meadows and Rep. Jim Jordan." This was an article in the Federalist, December 15th, 2021.
Without objection, who's next on our
Ms.
side?
Jackson Lee to strike the last word.
Ms. Jackson Lee. Gentleman from Texas, recognized for 5 minutes.
I thank you. I asked to strike the last word. I want to follow up on my friend from California, Mr. Issa, about the importance and the level of cruciality, I use that terminology, of this committee's work. It is constitutionally grounded, and there's no other committee in the House and its counterpart in the Senate that has the custodial responsibilities of the accuracy and the integrity of the Constitution. That means that we should take our work extensively and very seriously. we can begin to quote documents which include the very essence of our message. And I always like to remind you that the Constitution begins by saying, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility. But I'd like to focus on the idea of establish justice. We can procedurally try to maneuver my good friend's inactions of not showing this committee respect by not appearing and responding to the subpoena. I called Chairman Jordan my good friend because we've worked together for years. But you did not show up and present yourself to this committee, whether or not it was in this session or the last session. Now, as we proceed, we will hear on the other side a constant pointing to members who did their service on the January 6th committee. They will take pot shots at Mr. Schiff. They will find dated and unheard commentary that they will utilize, which I believe will continue to diminish the importance and integrity of this particular session and constitutional responsibilities of impeachment. I, too, was going to have misgivings of the amendment that would have joined Mr. Jordan, because I am not ceding the point that Mr. Biden, Hunter Biden, should be held in contempt. And I will continue that approach through the rest of this markup. There is no evidence. How can you have evidence of contempt when you have an open and public statement that I will appear? I will appear. I will use my constitutional rights of appearing with counsel, and I will come before the committee. I was there on that day when he was available to come. How can you argue that he did not come when you made no effort to indicate that we are waiting for you in the hearing room, set up for you to come now and speak? That was not done. And if I want to go a step further, I'm not suggesting to Mr. Biden that I would want that to be the case, but no law enforcement was sent to direct him to the Judiciary Committee room in 2141 Rayburn on the House side. Contempt. The only argument you want is to continue to give a circus-like atmosphere to this very important committee that, under the Constitution, is to be able to establish justice. Justice. There is no cause for what we're doing today. There is no basis for it. There is no evidence for it. There is no reason for it. Again, I do not believe Mr. Biden, Hunter Biden, should be held in contempt. All of the allegations that you have are simply that. Allegations of the abuse of power, the misuse of the relationship of father and son, all of that has to be proven. But you are going at it, and we will hear all of these bits and pieces and drops from the January 6th committee and so-called interactions between members on that committee that you either like or dislike, and we all will probably have a say in that. You cannot take away the sacred responsibility of the January 6th and this committee that is constitutionally grounded. So, Mr. Chairman, I want to be clear. I would not have been happy voting on that particular amendment because I think that yours should have been separate. And I do not believe that Mr. Biden, Hunter Biden, should be held in contempt at all, because I was there with you, Mr. Chairman, on that day, and you did not seem to make any effort to make sure that Mr. Biden knew he was welcomed in that committee at that time for us to hear him in an open setting. With that, I hope that we can establish justice in this committee for once and for all, and I yield back.
Gentlelady yields back. The gentleman from North Carolina, Mr. Bishop, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I submit that whenever you have an issue under debate, the surest sign of weakness in an argument is to avoid the question, to talk about anything but the question in issue. Now, I do compliment the gentlelady from Texas for her point just made. She focused on the issue, but I do eagerly undertake her challenge. She says, you cannot make an argument that Hunter Biden is in contempt. How can you argue he will not come? She said, when he said he would come. Well, here's how. He was issued a subpoena for a deposition. He stated publicly and in correspondence that he would not testify in a deposition, that he wanted to do it his way in an open hearing. Well, that's contempt. And it is open and shut, cut and dried, as simple as it can possibly be. So the subject under debate is whether an ordinary citizen who defies a subpoena of a congressional impeachment inquiry should be held to account. And there is also no need, really, to debate that. Quite to the contrary from the suggestion of the gentlelady from California, the weight is all on the other side. And interestingly enough, in the matters of Bannon and Navarro, every member of the minority is on record to that effect. Indeed, members of the minority have gone farther than that. Mr. Raskin has specifically addressed the purported basis for objection that Hunter Biden has offered, stating that the proper course is to first have private testimony in a deposition to explore facts thoroughly and in the way that that mode of examination permits, and then to have a public hearing after. Nobody that I can recall in the minority took issue with that point. But here's really the salient and final aspect that makes this clear beyond argument. This may be the most brazenly recalcitrant witness defying Congress in the history of the Congress that I'm aware of. Now, there may be some other situation in which this has been done. But the person who is subject to the subpoena, I hear the laughter on the other side, so let me go further. I don't know that anyone has ever come onto the complex in the shadow of the United States Capitol building, suborned and assisted by another member of Congress, a member of this committee, stood in the triangle and vowed to the media that he was defying the subpoena of a congressional impeachment inquiry. I don't know that that's ever been done. And I certainly don't believe that it's ever been the case that a member of Congress has made arrangements for that brazen defiance of Congress to be expressed on the Capitol, in the Capitol complex, on the plaza. So if you want to talk about the issue, it is not a close call. If you want to talk about what happened in the previous Congress and whether Congress can subpoena members of Congress to testify before a committee, especially when that committee has falsified and fabricated evidence to its eternal shame, then you can talk about those other issues. And I would if I were you, because you certainly cannot meet the simple proposition that is before us now. And you certainly cannot deny the duty of this committee to respond to that brazen defiance.
Would the gentleman yield?
I will.
And I promise I'll yield back to you down the road. But the point I would just make here is that the difference between Hunter Biden and, as you mentioned, Navarro and Bannon, is that Navarro and Bannon totally stonewalled Congress. They didn't produce any documents. They didn't offer to testify in any way, and they didn't provide any testimony of any kind. By contrast here...
Let me take my time back, because I've only got another 20 seconds. And I don't want to just leave, and we'll come back to it and have further colloquy if you like. And I appreciate the gentleman from Maryland's collegial interaction. I think that is a distinction without a difference. I don't think, in fact, I think it makes it worse that Hunter Biden goes to media and declares and decides how he will testify to Congress. He will come to a public meeting, but he will not do what Congress has commanded by a lawful subpoena. I don't think it's a distinction that favors him. I think it's one that requires us to act. And my time's expired.
Gentleman yields back. Who seeks recognition? The gentlelady from Washington is recognized.
Thank you, Mr. Chairman. Well, I appreciate the passion from my friend across the aisle and the outrage. I think we're all outraged about many things. But if we're going to talk about outrageous things that have happened or things that have never happened, let's talk about the fact that President Trump incited an erection. And maybe that too.
Yeah, you could talk about that too, I guess.
Maybe we should talk about that too. The president incited an insurrection. Maybe we should talk about the fact that the former president was impeached twice. Maybe we should talk about the fact that the former president was convicted on 91 felony counts. Maybe we should talk about the fact that the former president was charged with interfering with our elections. Maybe we should talk about the fact that most, if not all, of the members of this committee, certainly leaders in the House, have continued to support and endorse a person who has literally talked about being a dictator from day one. So, Mr. Chairman, I believe this markup is an unbelievable waste of time. My Republican colleagues have been investigating Hunter Biden for years. My colleague, Mr. Ivey, just gave very important statements about why this is a different case than others that have been cited. There's been no indication whatsoever that any of his activities are connected to the president. They have turned up nothing. So why are we really here today? It is another distraction from the fact that, in the words of one of my colleagues on the other side, in this committee, by the way, said on the floor of the House, this Republican-controlled do-nothing Congress has not delivered one thing that Republicans can go home and say that they delivered to their constituents. In fact, this Congress is on track to be one of the most unproductive in modern history. This Republican-led House has only passed 27 bills that became law in spite of holding 724 votes. We still have no reauthorization of the Farm Bill, no bringing to the floor of a bipartisan bill that we passed in this committee around surveillance reform. We are on the verge of a government shutdown, and you just compare that to 2022, when Democrats controlled the House with a razor-thin majority. We held 549 votes, and 248 bills were signed into law. Now, none of this inaction stops my Republican colleagues from celebrating all the funding for infrastructure and jobs that Democrats passed without a single Republican vote. Not a single Republican voted for the Inflation Reduction Act, and yet there are many that go home to their constituents and keep crowing about how they're bringing money home from bills that they never voted for. But aside from claiming the work of Democrats, Republicans have no achievements to run on. And the American people should make no mistake that this hearing is pure political distraction. My colleagues would have you forget that under the Biden administration, 2.7 million jobs were created just last year, more than any year under the previous administration. That is a total of 14.3 million jobs created under President Joe Biden. My colleagues would have you forget that starting this month, more Americans with diabetes will finally see sharp decreases in insulin prices. Thanks to President Biden's Inflation Reduction Act, people on Medicare now pay no more than $35 a month for insulin prescriptions. That is money in people's pockets at home. And these efforts put pressure on drug makers to lower their prices for people not on Medicare as well. House Democrats also passed and President Biden signed into law, making historic investments to lower prescription drug prices. We extended health care coverage to millions, health care that Republicans are just trying to take away, acted on climate change, spurred American chips manufacturing, all while creating millions of jobs, and finally starting to ensure that the wealthy pay their fair share in taxes. And that's not to mention that we as House Democrats used our gavels to pass the Women's Health Protection Act to protect the right to decide whether or not to have an abortion. We passed landmark legislation to protect voting rights, to protect the civil rights of LGBTQ Americans, common sense gun safety reforms, legislation to provide a roadmap to citizenship to dreamers and farm workers, bills that provided an increase to the federal minimum wage and protecting the right to collective bargaining, all with the slim margins that Republicans now blame for gridlock. What we did the last two Congresses is what real leadership looks like. We didn't waste months of staff time and taxpayer resources chasing empty investigations to score cheap political points. Reject this bad faith resolution, and let's focus on things that actually deliver for the American people. I yield back.
Gentlelady yields back. The gentleman from New Jersey, Mr. Van Drew, is recognized.
Thank you, Mr. Chairman. You know, we're going to dig through the law, we're going to dig through the statutes, we're going to dig through the rules, and it's important. But I want to talk about what the man on the street, the man and woman on the street really sees here. And it's called rules for thee, but not for me. Democrat leaders in their desperate attempt for power continue to rewrite the rules in an effort to maintain that power. They're manipulating the courts to keep a political opponent off the presidential ballot. They disregard democracy by all but canceling their own primary process to make sure that they coronate President Biden. Democrats on TV openly endorse the chaos on the border, claiming illegal immigration is a way to help them with future redistricting. That's what it's really about. A party that is desperate for power. Leaders that are desperate for power can never be trusted with it. And I pray that they don't get it, because it will rip apart the fabric of this country. The pattern we see here paints a clear picture, and it's what people on the street see. Democrat leaders believe they are better than all of us, better than everyone else. And there's no clearer example than Hunter Biden. A man who's paraded around the world with our adversaries, a man who cheats on taxes to the tune of millions of dollars, a man who spends that tax money on escorts, drugs, alcohol, and luxury hotels, a man who illegally obtains a gun and then illegally disposes of said gun and was going to get off with hardly a slap on the wrist. Any other American wouldn't receive that type of justice. A deal that would have cleared him of all illegal acts. Unbelievable. We had an honest judge who never saw anything like that, and she couldn't even do it for the president or the vice president. The corruption is so blatant, it's hard to believe when you say it out loud. The truth is, Hunter Biden's a bad guy. And his corruption goes all the way to the top, all the way to the president. And he needs to be held accountable. As for members of this very committee that have gone out of their way, a particular member, to help orchestrate the criminal act of defying a congressional subpoena, and let me address that. This is a standing committee of the United States House of Representatives. It isn't a select partisan hack committee set up by the former speaker that didn't hear anything from the other side of the aisle. Totally different. You can't relate one to the other. And of course, Mr. Jordan was willing to go, would have gone, but just wanted an outline of what the issues were really going to be, never received that. And the reason they didn't hold him in contempt, the reason that they didn't give him the information that they needed, because they knew they were on faulty ground, they knew that they were a partisan hack committee, they knew they didn't want to hear the facts, they knew they didn't want to have the truth. We have the other side of the aisle here. They can challenge, they can have a colloquy, they can go into debate. That didn't exist on that other committee. The purpose of that committee was to hang one individual. But when you think the rule of law is for thee and not for me, Hunter Biden and my colleague from California, those sanctions, they're unsurprising. Americans see the corruption, they feel it. They want Democratic leaders and powerful rich people to be treated like everybody else. The construction worker down the street sees it. The parents who want to speak out at a school board meeting see it. Traditional Catholics who want to worship their Catholicism and the government tries to spy on them sees it. The millions of Americans that were illegally surveyed by FISA, they see it. And if this committee doesn't unanimously today hold Hunter Biden in contempt of Congress, Democrat leaders will once again show the world their blatant disregard for the rules of this country and the core values that should bind all of us. Justice for thee, but not for me. The rules for thee, but not for me. The powerful, the rich, the Democrat leaders in control. It doesn't apply to them. It only applies to the people they want to get. God help us, I pray, for justice and integrity to prevail today. Mr. Chairman, I yield back.
Gentleman yields back. Gentleman from New York is recognized.
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I want to make a number of points. Number one, it was Merrick Garland, the Democratic Attorney General of the United States, who appointed the special prosecutor who is prosecuting Hunter Biden. So no one can say that we're letting Hunter Biden off. We appointed, or the Justice Department appointed, under Democratic auspices, a special prosecutor. Number one. Number two, we have never held someone in contempt who is willing to come and testify in public before a committee. The Republican majority on this committee has held 90 private interviews. One has been made public. Selective and misleading quotes have been released from the other 89. Selective and misleading. And they won't make the transcript of the entire interview public because that would show how selective and misleading the quotes are. Number three, let's talk about the real danger faced by this country. 3 years ago, an insurrection was launched against the lawful authority of this country, an insurrection designed to prevent the peaceful transfer of power, the first, in effect, revolution against this country since the Civil War. And it was mounted by Donald Trump. And people were hurt and killed in that attempted revolution, which is what it was. But now we seem to have forgotten it. Or at least the Republicans seem to have forgotten it. And don't forget the testimony right after the president was certified that night. The next day or two, the Senate Minority Leader, Mitch McConnell, the Republican Minority Leader of the House, Kevin McCarthy, both got up and said that Donald Trump was responsible for what had happened. McConnell said he should be prosecuted. He is being prosecuted. Republicans say that this is a weaponization of the Department of Justice. What nerve? A former president is being prosecuted for crimes committed in front of the entire nation. Everybody saw it. This president, or former president, says that if he is reelected, he wants to be a dictator. He wants to weaponize the Justice Department to prosecute his opponents. He says so. He says he wants to do the things that Republicans are falsely accusing the current Justice Department of doing. He says he wants retribution. I am your retribution. He says he wants the death penalty against the former chairman of the Joint Chiefs of Staff. That is what's really going on in this country. And here we have this committee with a farcical motion to hold Hunter Biden in contempt, even though, as I said, Hunter Biden is willing to testify in front of the committee. No committee has ever held someone in contempt who is willing to testify and says so on any date that the chairman wishes. The hypocrisy here is, I would say it's beyond belief, except the Republicans have shown it repeatedly in this session. If they hadn't, it would be beyond belief. It's unforgivable. It's subversive of freedom in this country. It's subversive of the notion of Republican with a small r government. And the Republicans ought to be ashamed of themselves. I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Speaker. My fellow Americans, Happy New Year. But I've got some sad news. Despite what some would want you to believe, this hearing is not about Hunter Biden, a man who is a private citizen, never before worked for the federal government, much less the executive branch. This hearing, ladies and gentlemen, is about Joe Biden. Joe Biden is president, and MAGA Republicans on this committee still cannot bring themselves to accept the truth that Trump lost the election. So they've made it their single-minded mission to do everything they can to get Donald Trump reelected. Their game plan is to impeach Joe Biden and make him a one-term president. And despite a year of an exhaustive joint investigation by this committee and the MAGA House Oversight Committee into Hunter Biden's laptop and Hunter's $1,300 a month highly suspicious car note reimbursements to his dad, House Republicans have come up empty on their crusade to impeach Joe Biden. Perhaps this is what motivated my good friend and fellow Judiciary Committee member Chip Roy to take to the House floor in a fit of frustration and say, quote, "One thing, I want my Republican colleagues to give me one thing, one, that I can go campaign on and say we did. Anybody sitting in the complex, if you want to come down to the floor and come explain to me one meaningful, significant thing the Republican majority has done," and he proceeded from there. I'll end that quote right there. But Speaker Johnson is like-minded, saying that impeaching President Biden is a, quote, political imperative, end quote. Speaker Johnson went on to say that, quote, people are getting anxious and they're getting restless, and they just want somebody to be impeached, end quote. So here we are with government funding deadlines to keep the government open, rapidly approaching, with our allies in Ukraine requiring urgent assistance, among a host of other topics requiring congressional action. Republicans are kicking off the new year not by passing legislation that would better the lives of the American people. Instead, MAGA Republicans are kicking off the new year by going after Hunter Biden for being in violation of a subpoena to appear at a secret, almost clandestine deposition, excluding the public and the media, after Hunter had offered to come before this committee to answer any and all MAGA questions in a public hearing. And what's so ironic is that Chairman Jordan wants to hold a man in contempt who has offered to appear when the chairman has been in complete violation of his own duly issued House committee subpoena for the last 608 days. Sadly, legislating is secondary to the MAGA public political agenda of impeaching President Biden. In fact, last year, the MAGA-led House passed only 27 bills. This House held 724 votes, but we couldn't even make 30 laws. That is less lawmaking than any other Congress in the last decade. In fact, last year, MAGA Republicans passed fewer bills than any other Congress since the Great Depression. It's embarrassing and it's shameful, especially when you consider that MAGA Republicans expended 5 weeks last year to elect 2 House speakers, wasting a grand total of 19 speaker votes. It was indeed a painful spectacle. And the dysfunction and gridlock continue into 2024 with only 9 days left before the government runs out of money. The voters did not send us to Washington to pave the way for the re-election of Donald Trump. They sent us to Washington to pass laws that make life better for them. Let's start doing real work on behalf of the American people rather than wasting time catering to Donald Trump. And with that, I yield back.
The gentleman yields back. The gentleman from Texas, Mr. Moran, is recognized for 5 minutes.
Thank you, Mr. Chairman. Move to strike the last word.
The gentleman is recognized.
Mr. Chairman, there is really a narrow question presented here today before this committee, and that is, should Hunter Biden be held in contempt of Congress for his failure or refusal to comply with a valid subpoena for deposition? That's it. That's the narrow question that's before this body today. That's the narrow question that's ultimately going to be presented to the whole body of Congress. And this matter is really about a procedural adherence to the law, more so than it is about the underlying substantive issues that we want to talk about. We have a valid and lawful and enforceable subpoena that has been issued to Hunter Biden for a deposition. It regarded a legislative purpose, and that proper subpoena must be complied with. There's no discretion there on behalf of the recipient of that subpoena to say when and how he wants to do it. It is by force of law that he must comply with the subpoena. That's point number one. I have two further points. Secondly, this is a matter regarding the acts and omissions of Hunter Biden, not others. I note that many of my colleagues on the other side want to talk about other people and other issues and other things that are irrelevant to this proceeding today. The proceeding, again, is a narrow question about Hunter Biden's acts and omissions as it relates to the subpoena that was issued to him for a deposition. That's it. Responsibility and accountability for decisions has to be individualized in this particular instance. When I was home over the break, I had lots of opportunity to deal with my two young children, my 6 and my 8-year-old, and oftentimes when I deal with them, what I find is when they're having an issue, I go to one and I say, "Why did you do this?" And he wants to point at his sister and say, "Well, she did this." He wants to deflect and talk about his sister's action. I have to respond and remind him, no, let's talk about your responsibility for your own decisions and the accountability that you're going to have for the decisions that you're making. That's what I feel like when I'm here today listening to some of the arguments on the other side. They want to deflect and say, oh, but let's look at somebody else and something else that happened years ago. Well, no, the narrow question is, what did Hunter Biden do or not do in response to the subpoena for testimony and deposition? That's the narrow question here today. The decisions of Hunter Biden have to have consequences. And that leads me to point number 3. Because if this body fails or refuses to hold Hunter Biden in contempt of Congress, future citizens will know that such subpoenas are meaningless. Whether or not they come from a democratically controlled Judiciary Committee or a Republican-controlled Judiciary Committee, they're meaningless. And in that instance, the legislative branch would be without power to effectively compel attendance. We do this over and over again as the Article I branch of government. We cede power to somebody else. We don't want to enforce it when it's tough. We have to hold ourselves accountable, and in this instance, we have to hold a private citizen accountable when they do not respond to a properly and validly issued subpoena. If we do not do that, then for years to come, other people will say, but Hunter Biden didn't show up. Why should I show up? There will be no consequences. I don't need to do this. Or maybe it's just that because Hunter Biden's daddy is the president, that's the issue, that he knows he's going to get coverage. It's clear to me that Hunter Biden believes he is above the law. This Judiciary Committee today cannot let it go. We have an obligation and a duty to hold this citizen responsible and accountable for his failure or refusal to respond to a valid subpoena for a deposition. Not a hearing before this committee, but a deposition. Any other American under subpoena would be required to attend, and any other American would not get the protection that Hunter Biden is getting in this instance. We must act strongly and stand firm, not just for Republican issuances of subpoenas, but for Democratic issuance of subpoenas in years to come, because one of these days the tables are going to be turned, and we must be consistent in the application of our law. With that, Mr. Chairman, I yield back.
The gentleman yields back. The chair now recognizes the gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Chair. Mr. Schiff, if you'd yield for a question first, I guess we're still on your amendment.
No.
Was that tabled or the table to appeal the motion to
They buried the motion to hold Mr. Jordan in contempt with one procedural motion, but that wasn't enough to hide it from the public, so they buried the procedural motion in another procedural motion, which was buried in a motion to appeal the ruling of the chair, which was tabled, and long and the short of it is they didn't want to discuss it, and they moved to a procedural mechanism where they could stop the debate.
Well, the thing is that what they were problem was they said that the subpoena to Mr. Jordan was in the last Congress, and therefore it's been, the statute of limitations has run. But what it really is about chutzpah, which in English, of course, is hypocrisy. But it's both chutzpah and hypocrisy, that Mr. Jordan would have to ask that a subpoena failure to comply be cited for contempt when he did the same thing. That chutzpah has no statute of limitations. Would you entertain another amendment that finds him guilty of chutzpah?
I would certainly be willing to modify my motion to simply hold him in contempt and not Hunter Biden, if that were desired by the committee.
Thank you, Mr. Schiff. Just some things have been said today.
I don't think that is desired by the committee.
Some things have been said today that I'd like to. Mr. Van Drew said that the January 6th committee just wanted to hang one person. No, it was hang Mike Pence. That's what they said on January 6th, not hang somebody else, individual one. And so I think he got confused in who was to be hung. And Ms. Jayapal did a pretty good job of talking about what they failed to do. But you forgot, today is an historic day. Today is a day like none other in the history of the Congress of the United States of America. The Republicans are getting us a new pen. Today we're getting a new pen. Never before have we had two pens in one Congress. This is the two-pen Congress. They didn't like green.
Will the gentleman yield as to the pen?
No, sir. Maybe it's the wicked that they don't like the connection with the play, which was green, and it gave green a good name. We're getting a new pen. We're getting a new pen. But the fact is, this is not about Hunter Biden. This is not about subpoenas. This is about Joe Biden, and it's about this committee and much of the Republican Congress trying to reelect Donald Trump, who has 91 indictments, 91 sightings and indictments, 2 impeachments, God knows how many lies, and they want to help get him back in power, who he says he'll be the dictator just on day one. And on day one, of course, what he'll do is he'll declare a national emergency and a national situation where he'll empower the military and to come under his command to go after people and arrest people and to do things that have never been done in America before. That will be a dictatorship that he will announce on day one and will continue through history. But he's not going to be elected because the American people are not capable or willing to be conned by the #1 con man that this nation has ever known. He has conned many of his supporters. And I read on January 6th on responses to emails or to social media sightings that that group believes that it was Antifa and the FBI that led the assault on January 6th. They had masks on to make them appear to be MAGA. I guess the Antifa and the, which is not a Democratic group, it's some kind of group out there, Antifa, they're liberal, they're not Democrat. And that they and the FBI got involved in the insurrection and urged it on and were responsible for it, and it was all a false flag. And these people believe it. They have bought one of the biggest lies ever propounded or promoted by an American president. And the president continues to do it, to talk about the election. And there were people in this Congress who supported overturning the election. I think 140 people on the Republican side voted to not accept the Electoral College votes of Arizona and/or Pennsylvania. It's scary what's happened, and this is part of it. This is a continuation of rewriting history and making people out there who apparently didn't go to the colleges that have the presidents that Ms. Stefanik is trying to remove. Anyway, this is chutzpah, and I yield back the balance of my time.
Gentleman yields back. The gentlelady from Indiana, Ms. Sparks, is recognized.
Thank you, Mr. Chairman. I want to make a couple brief remarks on just some of the issues that were brought up from other side and then kind of get to the subject. No, honestly, I agree. Last Congress, the other side passed a lot of very bad bills. I don't think quantity of bills is a good legislation, and actually wasted a lot of money. And unfortunately, they had control on all houses and presidency and were able to do a lot of bad legislation and not dealing with the real issues affecting Americans, crushing debt, inflation, and the spending, and and what's happening in our border is very destructive for our country. And they don't want to do, and they don't even want to find bipartisan agreement on these issues, this Congress, which is very sad for me to see. I know there is a lot of discussions about, January 6th, and I've been in the chamber January 6th, and I'll tell you something, we call this insurrection. I'll have to tell you, if the people that show up there wanted to do it, they would have succeeded, but they didn't show up for that reason. It was people that were upset because the quality of people came there. They were mad because we are not governing for the people. And that's unfortunately what was very strange to me, that Speaker Pelosi didn't have a security. Speaker Pelosi insisted for us to stay in the chamber, where I personally demanded to leave that chamber. So a lot of things, the other side dropped the ball. And it was very unfortunate for me to see that. So I think this is beyond the subject of this matter, but we need to stop, accusing people that disagree with the government that's been very corrupt and oppressive, to actually come here and, express peacefully their dissatisfaction. And there are always some bad players, and who knows who they are. But we don't call all people insurrectionists. This is just un-American to do it. And I'm sick and tired of the other side constantly doing it, because I knew a lot of people that were there in the crowd, and they're good Americans, patriotic, that love this country. But go further. I know that maybe, Chairman Issa said it might be a waste of time, and Hunter Biden is going to invoke the Fifth Amendment. But you know what? What he's doing right now, beyond that, it is a blatant disregard of congressional subpoena. That's how he does. He actually dares enough. No other American would show up actually in the face, of Congress and defy and say, I'm going to decide how things are going to happen. This is just disrespectful. Only someone who thinks a little too much of himself would go actually do something. People might disagree, fighting in the courts, but not in the face. As Representative Bishop said, that is actually extremely disrespectful to this institution to do what he is doing. And if we look at the matter of the fact, we can debate and try, to get attention to other issues and deliberate, but ultimately, I think that should be, and Representative Moran said that is setting up a very bad precedent. If the other side decide, that, somebody can just act like that with the Congress, they might shoot themselves in the foot, because next Congress, there could be something different, and they will be on the other side, because we're setting up a precedent, but somebody's going to decide if they're going to comply or not with the deposition subpoena. And I don't think this institution, should allow that happen. If this is a very serious impeachment inquiry, if Hunter Biden wants to explain what's happened, he has a chance to come. And it's not like in a deposition you have just one side. You have both sides, equal amount of time. Everything can be questioned. So it's a very bipartisan process, but not a 5-minute presentation that will just go until he do just here for 5 minutes talking points with his lawyers. And it's not going to really get to the subject matter, because subject matter at stake, it's extremely serious. I think we should start taking actually impeachment inquiries and proceedings much more seriously than the other side did. It's not a politics, it's not a joke. We're a serious institution, and I do not think people think that way here now, and it's unfortunately what we have became. We became a circus, entertainment, and talking points, and not really looking at issues seriously. It's sad for me to see, and I think this is a reflection, on where we are heading as a republic, and it's a sad reality. But we have to decide, are we going to be adults in the room and start looking at the issues, or we're just going to do presentations here? So I think if we go to the narrow matter of the discussion, do we allow anyone to defy the congressional subpoena? And the other sides will have to make a decision how they're going to vote for that. But they might regret that they're doing politics right now. So I hope they will rethink this and support in this resolution. So I yield back.
Gentlelady yields back. Gentleman from California, Mr. Schiff is recognized. And then we'll go to Ms. Ryan.
Mr. Chairman, once again, we hear an effort to reinvent January 6th, this time as people expressing peacefully their disagreements with the government January 6th was not a peaceful expression of differences with the government. It was a massive, violent attack on the Capitol with the object of overturning a free and fair election. Mr. Jordan cut off debate on my amendment to hold him in contempt, so we couldn't discuss what his role was, why he was subpoenaed, and whether he should be held to the same standard as a private citizen. And while he said quite erroneously that he was not required to testify, either because he took issue with the object of the investigation or because the speech and debate clause, as Representative Lofgren pointed out, that does not apply to subpoenaing a member of this body. Let's remember who did step forward, and let's ask ourselves not why he was compelled and refused, but why he didn't volunteer to come forward, why he was unwilling to share his information, why it was even necessary to subpoena him. After all, so many others did their constitutional duty. Republican Speaker in Arizona, Rusty Bowers, talked about how he was compelled by his oath, by his faith, by the Constitution, to do his constitutional duty, to refuse the former president's entreaties to overturn the election. And he showed his devotion to our country and the Constitution by coming and testifying. Jim Jordan would not. Brad Raffensperger, the Republican Secretary of State in Georgia, did his constitutional duty both to protect the vote in Georgia, to ignore the former president's demands that he find 11,780 votes that didn't exist, but also to come and testify, to share with the country what he knew, but not Jim Jordan. Cassidy Hutchinson, a staff member at the White House, showed extraordinary courage to come forward, showed her devotion to her country and Constitution, and came forward and testified, but not Jim Jordan. Capitol Police officers who were beaten and gouged that day, they came forward and testified, but not Jim Jordan. White House counsel, Republican White House counsel came forward and testified, but not Jim Jordan. And lest we forget why the committee wanted Jim Jordan, let's look at our referral to the Ethics Committee over his failure to come forward for guide as to why we wanted his testimony. Representative Jordan was a significant player in President Trump's efforts, we wrote. He participated in numerous post-election meetings in which senior White House officials, Rudy Giuliani and others, discussed strategies for challenging the election. Chief among them claims that the election had been tainted by fraud. On January 2nd, 2021, Representative Jordan led a conference call in which he, President Trump, and other members of Congress discussed strategies for delaying the January 6th joint session. During that call, the group also discussed issuing social media posts encouraging President Trump's supporters to march to the Capitol on January 6th. An hour and a half later, President Trump and Representative Jordan spoke by phone for 18 minutes. Yes, we wanted him to come testify about what he discussed with President Trump for 18 minutes. And no, Jim Jordan has never told this body why he was unwilling to tell the country about that conversation in the run-up to a violent attack on the U.S. Capitol. Or why he spoke with White House staff about, as we wrote, the prospect of presidential pardons from members of Congress. He was unwilling to say why he thought pardons from members of Congress might be necessary. And today, he's unwilling to tell us why there should be a different standard for a member of Congress who is subpoenaed than for a private citizen, and why the standard for a private citizen should be so much higher. My colleagues on the other side of the aisle say that's not a germane question. We love to hide behind germaneness when we really don't want to answer the root of the matter. And the root of the matter is, why is Hunter Biden's failure to appear worthy of a criminal contempt, but the chairman of the Judiciary Committee's unwillingness to comply with a congressional subpoena gets nothing more than a shrug? That's really the question before this committee today. And so far, there is no answer. I yield back.
Gentleman yields back. The gentleman from California is recognized.
I love following my colleagues from California because it gives me so many more things to talk about. Congressman Schiff, you and I came into Congress together almost 24 years ago. We've seen a lot. We've seen a lot in this committee. But whenever I'm in a markup and one side wants to talk about something that's not on the table and the other side says, well, why don't we talk about what's on the table, the whole thing gets lost. Well, I want to bring it back to what is really at stake here. This committee has subpoenaed an individual in which there is a substantial amount of information related to the wrongdoing of not just himself, but potentially the President of the United States, the then Vice President of the United States. That's what we're dealing with. We're dealing with an investigation of the then Vice President of the United States and his son, who had special access, who flew on Air Force Two, who today had the committee room next to us swept so he could come in and make a little staged appearance. We're not dealing with a private individual, as my colleague from California said. He's not a private individual. He is the son of the president. He is a man who has flown around the world using his last name being his father's last name, to make millions of dollars, much of which he hid from the IRS and didn't pay his taxes on. That's who we're asking to come in a private session, not a staged public event, and answer questions if he will. As a gentlelady from Indiana said, Ms. Sparks, I said he might or probably would take the fifth. He hasn't said he'd take the fifth. That would be an assertion that his people could make, and that the chairman would look at that. What he has done is simply thumbed his nose at the American people and at this body. It's that simple. It has nothing to do with what went on in the last Congress. It has nothing to do with what went on years ago in the election of President Biden. And yet one side would have you hear about Jim Jordan not showing up for a committee that he sent letters back to telling him why he needed to know things and he wanted to negotiate his appearance, which is not uncommon for any witness, particularly a member of Congress, asked about his private conversations between him and the President of the United States. We all know the President of the United States has an absolute right to ask for and receive information in confidence, and we have been told for years on both sides of the aisle that we do not have access to that correspondence related to decision-making of a president, and yet we're acting like they're the equivalent of somebody who has committed crimes, Hunter Biden, who has used his position as the son of the president to fly to China, make business deals, and then fly home with daddy on Air Force Two. We are clearly looking at somebody who has done wrong, has used his family name to do wrong, but more importantly, we are looking at whether or not there was a connection in funds flowing to the president and or the president, then vice president, taking action as a result of funds flowing to he or other family members. It's that simple. We are doing a serious investigation of real wrongdoing, and an individual who has done wrongdoing, no question about it, is refusing to come, but has the, as the congressman who's no longer here from Tennessee says, he has the chutzpah to show up in the committee room next door or use the Secret Service to do so, just as before the break, he showed up across the Capitol using Congressman Swalwell's name to get himself a place to have a staged press conference. Well, we sat in this room waiting for him to show up, all the court reporters, the chairman, the ranking members doing their job because we expected him to show up as subpoenaed for a deposition. So let's get back to the basics. This is a contempt because he has been contemptible of not just not showing up, but how he has thwarted and given us the middle finger, if you will, to the American people. And when somebody flips the bird to the American people or the United States Congress or to the power of legitimate government actions, yes, that's what referral for contempt to the federal court should be, and I insist on it, and with that, I yield back.
Gentleman yields back. The chair recognizes the gentleman from Maryland.
Thank you, Mr. Chairman. I've got quite a few things to respond to. I want to start with the comment from the gentlelady from, I think it's Indiana, regarding the peaceful nonviolent protest on January 6th. The irony of that for me is, you know, I grew up during the civil rights movement. Dr. King's birthday is one that we celebrate on Monday. And I gotta say that if she wants to see an example of a peaceful nonviolent process or protest, I hope she'll, you know, watch Montgomery to Memphis or take a look at the civil rights movement, because that's what a nonviolent protest looks like. Dr. King didn't show up with bear spray. He didn't show up with any kind of weapons. He didn't break into any kind of locked buildings. They didn't do anything like that. If there was any kind of violence during those protests, it was perpetrated by the police, Bull Connor and the like. Next, I'd like to say this. The Republicans keep saying, you know, we want to try and get this information. It's important. President Biden is, you know, under investigation, blah, blah, blah. Here's the problem with that argument. You could have gotten it right there at the table. In fact, Mr. Issa just referenced the meeting. We were sitting, I think it was the next room, waiting for Hunter Biden to show up. Well, A, that's incorrect because he said he wasn't coming for the deposition. But if they decided, you know what, we can do a hearing right now. They had the court reporter there. We're in a hearing room. The members just come up to the dais and give them a chance to speak. We could have done it right then. In fact, we could do it today if you guys would just move off of this hardline position about it's got to be a deposition. It can't be public testimony. We could do it now. We could do it now. So the problem when you start talking about contempt, by the way, this is criminal contempt. This is, you're saying that he's got the intent to deny this committee information that it's seeking. And all the cases you cite in your report go to that point. But he's not denying the information. In fact, in contrast to some of the other folks we talked about, Navarro and Bannon and the like, they stonewalled it. He has not. He has not. And the last point I'll make, and I'll give you some time if I can, with respect to the chairman's responses with respect to the select committee subpoena. And I think it's a fair point that the congressman from California made. You know, Mr. Chairman, you could have testified if you wanted. In fact, if you'd met the Hunter Biden standard, you could have publicly testified, just like he's offered to do. And by the way, it's not too late. You know, if you want to make that happen, we can do that, I'm sure. But the other point I want to make is this. One of the things the chairman did in sending a letter back to the select committee was he put conditions on him coming to testify. Conditions that he would never permit witnesses now to assert. For example, he requested material from the select committee, including all materials referencing him in the select committee's possession, and all internal legal analysis related to the constitutionality of the members' subpoenas. If the members, I don't even know how many compliance hearings we've had with respect to Department of Justice, but if they'd made that assertion, you would have to peel these guys off the ceiling. And by the way, we've got members demanding DOJ line employees and other line employees at the government level, having them come in to testify, which is unprecedented, by the way, especially in the middle of a criminal investigation. You're bringing line prosecutors in here and compelling them to testify, or even asking them to testify, in the middle of a criminal investigation, and they're complying with you. By the way, I've told them I disagree with that position. I think they should just outright say no, because that's what you did, that's what the Republicans did, and that's what the previous executive branch administrations have done. They've asserted privileges that the Biden administration has not. And yet here we are. You're going after, and he's not a public figure, not a public official, by the way. Hunter Biden's a private citizen, which distinguishes him from all the executive branch cases that are referenced in your report. He's a different person. He's offered to come in and testify. He's a private citizen who does it and doesn't have to do it. And there's absolutely no reason we should hold him in criminal contempt. With that, I yield.
I thank the gentleman for yielding. And just to distinguish my California colleague's argument that Jim Jordan didn't have to appear because there's some executive privilege covering his conversations with Donald Trump, much as I respect my colleague legally, that's nonsense. The executive privilege applies within the executive. A president can't say to a member of Congress, you can't describe my conversation that I had with you. And in fact, even within the executive, we had the testimony of White House counsel and other close advisors of the president's have been testifying before the grand jury because the courts have rejected that argument where the president was engaged in potential criminality.
Gentleman from
I yield back.
Gentleman yields back. Gentleman from Virginia is recognized for 5 minutes. Would the gentleman yield for just a second?
Yes, Mr. Chairman.
Just in response to Mr. Ivey, the reason I sent the 11-page letter to Mr. Thompson that I'm haven't received a response from was because asking for the reasoning and the analysis on the subpoena was because he had said so. He said, we're studying the matter. We're not sure we can do it. There was doubt there, so we said, well, provide us what now, because now you've changed your position, you've issued the subpoena, so we just asked for that. We've yet to receive that. But that's why we did it, because the chairman actually said that.
Would the gentleman
yield
yield?
to the gentleman from
gentleman
Virginia. It says gentleman from Virginia's time.
I thank the chairman, and that was going to be my first request, is that your letter of June 9th be inserted for the record.
Without objection, it'd be entered in.
And let's run down that timeline, because you were first approached in late 2021 about appearing before the January 6th committee. You responded on January 9th, 2022, stating that you had no relevant information would assist, but wrote that any information you could provide would relate to performance of official duties. May 12th, Chairman Thompson subpoenaed you. May 25th, you requested information and materials from the committee. May 31st, Chairman Thompson widened the scope of information sought. June 9th, you responded again. So the last communication was you responding, trying to negotiate the appearance before the committee. Mr. Ivey has been an attorney in private practice. I've been an attorney in private practice, representing clients in receipt of subpoenas, and also a prosecutor actually issuing subpoenas. And there's a thing called reasonable accommodation, which I know my friend is familiar with, where you try to reach an agreement about how that person will comply with the subpoena. And I'm not going to yield at this point, but I will say that this is very different than what we've seen from Mr. Biden. And Mr. Ivey sits on the subcommittee that I chair, Responsiveness and Accountability to Oversight. We've been charged with trying to encourage responsiveness instead of stonewalling to consistently requests for information from this committee being ignored by this administration. So the idea that somehow the son of the president is doing something that is different than the administration is actually not that unusual. But what we have here is continued stonewalling by Mr. Biden. On December 7th, we issued the committees issued a joint deposition notice for him to appear on December 13th, and he didn't appear for his deposition. The last communication was actually not from Mr. Biden asking for more information. Mr. Lowell did send a letter on December 6th, but that the committee actually responded that day, the same day, reiterating that the subpoenas do not provide Mr. Biden a choice to make, and rather the subpoenas compel him to appear for a deposition. And let's talk about which committees we're talking about here. This is, again, a standing committee of the House of Representatives, the Judiciary Committee, as opposed to the January 6th committee, which even the chairman himself actually was quoted as saying, I think there are some questions as to whether we have the authority to subpoena colleagues. We're looking at it. And they never actually arrived at a conclusion as to whether that was allowable under the rules, and challenged by many of my colleagues. So the chairman of this committee never declined to testify, whereas Mr. Biden seems to want to violate all norms and procedures of proper subpoena procedure and compliance and reasonable accommodation, and dictate to this committee the time and place and manner in which he will appear. Instead of making appearances down the hall at oversight committee hearings to thumb his nose, instead of somehow cooperating with members of the minority to arrange for press conferences on Capitol grounds. Can you imagine if Mr. Bobulinski had done that? what the minority would do if those who January 6th were seeking testimony from and who did not comply actually held press conferences on the Capitol grounds or came to adjoining committees to sit and smile at the members of the committee while they tried to get information. Heads would explode on that side of the aisle. So with that, I urge my colleagues to support this motion. It is time to get compliance with this committee's responsibility for oversight, and I yield back.
Gentleman yields back. The gentleman from California, Mr. Liu, is recognized.
I move to strike the last word.
Gentleman is recognized.
Last term, when Democrats were in control, we passed a number of laws to move the American family forward. We passed the Bipartisan Infrastructure Act that created a lot of good-paying jobs. We passed the Bipartisan PACT Act that helped our nation's veterans. We passed the Bipartisan Chips and Science Act that brought chip manufacturing back to the United States and created even more good-paying jobs. This term, under Republican control, what do we have? We have impeachments and expulsions and contempt proceedings because Republicans have no agenda. Under Democrats, we created a record number of jobs last year. We had GDP growth above expectations, unemployment at a 50-year low, and the stock market reaching record highs. And what are we doing here this week? Not one, but two hearings under Republican control on Hunter Biden. I can guarantee you no American family over the holidays was sitting around the kitchen table thinking, gosh, that Hunter Biden, he's willing to testify publicly under oath in front of Congress, but he won't do a closed-door deposition. We really got to hold him in contempt. No American family was thinking that. None of this helps move the American family forward. And the reason we have not one but two committee hearings doing this today is because the Republicans have no agenda. We are 9 days away from a government shutdown. Are we doing a single appropriations hearing on the floor this week? No. Instead, what we got this year was we had the Republicans bring us to the brink of not one, not two, but now three potential government shutdowns. We had a Republican majority bring us to the brink of a catastrophic default on our nation's debts. And we had a Republican majority taking out their own speaker. We have chaos on the other side, and because they can't agree on anything, they're doing these stupid proceedings. And it's particularly stupid because Hunter Biden showed up today to testify publicly under oath. Why are the Republicans scared to let him testify publicly? What are Republicans hiding from American people? What don't they want Hunter Biden to say publicly? Ask yourself that question. And let me make one more point. None of this is going to matter because Hunter Biden substantially complied with the subpoena. The subpoena said, we want your testimony. He said, okay, I will come to you at a time and place that you choose. I just won't do a closed-door deposition, but I'll come to a time and place here in this committee room and testify publicly under oath. That is substantial compliance. That means the Department of Justice is never going to enforce this subpoena. So we're spending all this time wasting taxpayers' money when we should be focused instead on how do we move the American family forward? How do we lower costs, create more jobs, and increase GDP growth? That's what Democrats want to work on. I yield back.
Gentleman yields. Chair recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for 5 minutes.
Thank you, Mr. Chairman. The question's come up numerous times. Why won't he sit for a closed-door deposition, which was brought up by my colleague, Mr. Bishop, earlier? I'm not sure what the issue is. Why won't he sit for a deposition? I think he's just...
Would the gentleman yield for an answer to that question?
I don't yield right now.
Mr. Fitzgerald controls the time.
I'm not sure why, but I'm sure it's the barrage of questions that, quite honestly, would probably incriminate him. My colleague, Mr. Ivey, earlier talked about being a private citizen. And the problem is that Hunter Biden has a business card, right? And I'm not sure how many business cards he has, but I think most of them would simply say the president's son, right? I mean, that's clearly what he's doing. I mean, if he's down the hallway today in oversight, willing to sit in the back row and smile at the members of Congress to defy, obviously, the subpoena, he still hasn't found a job like he was asked about by a judge much earlier in the year, last year. So it's straightforward that the president's son not only defied a legally issued subpoena, but both House and committee rules make it crystal clear, as many of my colleagues have said before, that we have subpoena authority, which was communicated on multiple occasions to the president's son and his counsel. His decision to ignore the deposition subpoenas in favor of a public hearing, it doesn't somehow absolve him from the constitutional mandated duty to comply. So there's been a lot of discussion about other items, I think, here today, but let's go back to the bottom line, and that is that he is under a subpoena by the U.S. House of Representatives to sit and comply with the subpoena. It's not a suggestion. It does not deserve special treatment. It is what it is. But more than that, his refusal to testify seems to support the notion that, he doesn't want to incriminate himself, which, I understand. Then simply take the fifth. Again, Mr. Bishop discussed this earlier. Is this simply kind of a charade in front of Congress to ultimately say, okay, I'd be willing to come in and sit? We don't know what he would say in a public hearing either. But this committee, Judiciary Committee, not only has the wherewithal, but the responsibility to take this seriously. We know through public record requests and the depositions of business associates and government officials that foreign money was received by the president's son and the Biden family, and that those payments led to favors or special treatment by the President of the United States, and that large, quote-unquote, reimbursement checks were issued to President Biden shortly after that. We all know through testimony from the president's son and his business associate, Devin Archer, that President Biden was at the center of this family's business dealings. Mr. Archer put it, quote unquote, the brand. He was on speakerphone with his son approximately 20 times. He was allegedly sitting with his son when Hunter Biden pressured a Chinese energy company, and he received 10% for his troubles. It's a joke. It's on T-shirts. You board any airplane in America right now, and it says 10% for the big guy. Further, it appears that foreign nationals sought to influence public officials through their family members. This presents legal and ethical questions that need to be answered. And the president's son is afraid that a closed-door deposition may support some of these accusations. That's what's going on. I don't think anybody's being fooled by the discussion that's happening here today. So I just reiterate my support for the idea that we should continue to press to get the president's son in a deposition setting and get to the bottom of this so that the people of the United States of America understand that their president is not part of this. Unfortunately, I think he is. I yield back.
Gentleman yields. Chair recognizes the gentlelady from Vermont, Ms. Balin.
Thank you, Mr. Chair. I move to strike the last word.
Gentlelady is recognized.
Thank you. My constituents ask me all the time, what's the most difficult part of serving in Congress? And for me, it is confronting the deep cynicism. This hearing is not about transparency. It's not about accountability. Our committee has conducted 90 interviews or depositions this Congress, and to date, the chairman has released exactly one transcript. The one transcript that was released after we Democrats complained and asked him to release it to the Judiciary Committee in a hearing. The chairman won't let Hunter Biden testify publicly, and he hasn't been releasing the transcripts of interviews that have taken place. The public, as my colleague said, regular people deserve to know what this committee has been doing this Congress. I agree. The public, regular people, should see that in interview after interview, Republicans advance conspiracy theories wholly unsupported by evidence. Instead, the chairman continues to call witnesses behind closed doors, and I fear that's because the facts don't support the allegations. That the evidence would actually show that Republicans put forward claims that are baseless and false. So let's talk more about those real people, those regular people who send us here to do work on their behalf. Not only are the chairman's investigations a cynical waste of time, but they have put the lives of regular people in danger. Witnesses that have appeared before this committee have testified that House Republicans have spread dangerous conspiracy theories about them, and it has led to threats against their families and against them. Regular people, regular Americans. For instance, after Chairman Jordan posted an edited video of her on Twitter, one witness who was 9 months pregnant at the time had to get a restraining order against a man who repeatedly doxed her family. She had to disguise herself to go to prenatal visits because of the stalking and of the tens of thousands of death threats that she experienced. She ended up having to hire a private security firm that recommended that she not leave home. Witnesses who are members of law enforcement have testified that they've been doxxed, that they have gotten threats not just at work, but at their homes as well. And beyond that, witnesses have described threats to their families and to their children. They've described threatening letters being sent to their family members and having to move houses because their addresses have been posted online. Many of the 90 interviews that the committee has conducted this Congress have been with ordinary Americans, regular people who are just trying to do their jobs. Republican investigations this Congress have jeopardized the health and the safety of everyday Americans, regular people, the people who sent us here to do work on their behalf. This committee appears to be more interested in advancing conspiracy theories than in doing our jobs, serving the people we represent, those regular people. The posturing here in this committee is rooted in a deep, dangerous cynicism, a cynicism that threatens our very democracy, and it is very hard to watch. I yield back.
Lady yields back. Chair recognizes the gentleman from California, Mr. McClintock.
Thank you, Mr. Chairman. First, I agree with Mr. Liu and other Democrats who've spoken today that it was a tragedy that we lost many months of productive work because of the chaos created by the removal of the Speaker. But I would remind them that the Republican majority didn't remove the Speaker. Every single Democrat in the House, joined by just 8 Republicans, removed the Speaker. And under that Speaker, this House had passed landmark legislation to secure our borders, unleash American energy independence, and cut hundreds of billions of dollars of red tape. And to his argument that the economy is doing just great because of this administration, here's the one question they fear the most. Are you better off today than you were 4 years ago? Everybody knows the answer to that question in their own lives, and they will vote accordingly. And that obviously terrifies the Democrats, and it should. But all of that's irrelevant to the question before us today. The question before us today was perhaps best expressed just the other day by President Biden himself. On January 5th, the president attacked those who he said, quote, traffic in lies told for power and profit, and who are driven by grievance and grift. Well, we're here because of concern that for many years, the president has been doing exactly that through a complex family influence peddling scheme. These concerns are backed by a growing trove of documentation, emails, testimony of associates, bank records, FBI informants, that paint a troubling picture of a family influence peddling operation over many years, in which the central feature was access to Joe Biden, involving millions of dollars of payments to family members and perhaps to Biden himself. Now, Joe Biden clearly, unequivocally, and forcefully has maintained that he had nothing to do with that operation. He never spoke to his family about it. So what is so hard for the family member who collected all of these millions of dollars of foreign payments at the center of all of this to come here and say so? The only answer I can think of is that Mr. Biden has been telling lies for power and profit, driven by grievance and grift. I hope there's another answer that would exonerate the president. And I would think that he, above all, would want to put those suspicions to rest. If there's nothing to these suspicions, just say so. How hard is that? And if there is something to these suspicions, the Fifth Amendment rightly protects all Americans from being compelled to provide self-incriminating testimony. That might be embarrassing, but no further information can be compelled. Instead, he's chosen to thumb his nose at the lawful subpoena of Congress, a subpoena that presents no questions as far as its legitimacy or constitutionality. And that act is contemptible, and it is criminal, and it cannot be allowed to stand. I yield back.
Gentleman yields back. The gentleman from Texas, Ms. Jackson Lee.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Gentleman from Arizona reserves a point of order.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of
Amendment will be considered as read. The gentlelady is, while we're waiting to get the amendment, but the gentlelady may begin explaining her amendment.
Thank you very much, Mr. Chairman. I just returned from the Homeland Security Committee, and I again want to assert the comments of my ranking member, Mr. Chairman, and I hope that maybe in the interim you would correct that procedural injustice, if you will. I don't believe that there's any facts basis for Secretary Marcus to be impeached, but certainly the actions should be retained of impeachment by this Judiciary Committee. I wanted that to be on the record. As I said, there's an amendment at the desk, Jackson Lee, and my amendment notes that the House Republicans are continuing to harp on an investigation that has produced no evidence of wrongdoing. Specifically, my amendment will do the following. On page 7, strike the sentence that reads, "Information held and known to Mr. Biden is vital to the impeachment inquiry of President Biden and the committee's ongoing efforts to craft legislative reforms to federal ethics and financial disclosure laws." On page 7, after the sentence that begins throughout 2023, insert the following. Congressional Republicans have received dozens of hours of testimony from government officials and former Hunter Biden business partners and obtained troves of documents in response to their requests. This includes more than 37,000 pages of bank records, including personal bank accounts of Biden family members and other private citizens produced by 9 different banks. In addition, the Biden-Harris administration has cooperated extensively with congressional Republicans' probe. This comes on top of evidence collected by Senators Johnson and Grassley as part of their 2020 investigation into Hunter Biden. Instead of focusing on passing meaningful legislation or act on imperatives for the American people, and mind you, coming out of Homeland Security, meaning fix the immigration system, House Republicans have instead focused solely on this investigation, an investigation that has failed to reveal any evidence of wrongdoing by President Biden. Furthermore, to the extent that the Judiciary Committee has been investigating the Department of Justice handling of the Hunter Biden criminal matter, the evidence has shown that the department has handled this investigation apolitically and in accordance with all relevant statutes, guidelines, and policies. the same statutes, guidelines, and policies that apply to all criminal matters. The evidence also shows that much of the purported evidence behind this investigation on further scrutiny is not grounded in reality. For example, when Oversight Committee Chairman James Comer falsely claimed that China, through Hunter Biden, made payments to now President Joe Biden in 2018, bank records clearly demonstrated that the payments from Hunter Biden, as we have heard, were made to Joe Biden to repay a car loan for a 2018 Ford Raptor truck. On page 7, strike the sentence beginning, "The committees have collected evidence," through the remainder of the section, which ends on page 11, "to influence foreign business abroad and enrich the Biden family." I am glad to have been able to explain my amendment. It is unfortunate that we are here today engaging in this markup, which is nothing more than a political exercise, some would say stunt, and an embarrassing waste of time. I started out this morning by saying the highest regard that I have for this committee and the service that I've been honored to encounter. We've done many good things, and in the last two Congresses, under Chairman Nadler, we have passed amazing legislation, even brought back to life the Violence Against Women Act that we have struggled with for over 5 years. So rather than passing legislation, indeed, to help the American people, my colleagues across the aisle are broadcasting their sole agenda for 2024, impeaching President Biden to help reelect Donald Trump. To that end, Chairman Jordan, claims to have evidence suggesting that the Department of Justice impeded the investigation into Hunter Biden. I don't believe there's anything that could be further from the truth, when in fact the witnesses he has brought before the committee, including Special Counsel Weiss himself, have completely refuted this claim. Witness after witness has said that there was no political inference and that the investigation was run by the book. But rather than being honest with the American public, Chairman Jordan is hiding the transcripts of these witnesses' testimony and obscuring the truth. We can do better, Chairman. We worked together on many good issues. Hope we'll continue to work together. I'd like to see us pass human trafficking, anti-human trafficking legislation. I hope one day we'll be able to do that.
Time of the gentlelady.
I would ask my colleagues to
Time is
support
expired.
the Jackson Lee amendment, Mr.
Gentlelady
Chairman.
yields
Thank
back.
you.
The
I
gentleman,
yield back.
this gentleman from Oregon is
Thank you.
recognized
Chairman,
on
I'll
the amendment.
withdraw the point of order.
Point of order is withdrawn. The gentleman from Oregon is recognized on the gentlelady's amendment.
Thank you, Mr. Chair. And first, I'd like to offer to be included in the record the committee discretion to obtain witness testimony. Todd Garvey, Legislative Attorney, December 22nd, 2023, Congressional Research Service.
Without objection.
Mr. Chair, I find the use of the phrase "unfortunate" by the gentlelady offering the amendment much more applicable to the activities of our current president than to the activities of this committee. It's unfortunate that our president has engaged in, at least on the face of things, influence, the sale of influence offered by his son, or the sale of access offered by his son. And what I think we need to be keeping in mind, and the language in her amendment so clearly gives us the opportunity to call out the purpose of this hearing, which is to say, what is it and why is it that we need Hunter Biden as a witness so badly? And the answer, of course, is that the nation believes, at least polls indicate, that the sale of influence was occurring for years between Hunter Biden and his father. Now, is that true? Well, that's why we're having the inquiry to find out whether or not it's true. Whether or not Joe Biden was directly involved or benefited from the corrupt practices of his son, Hunter Biden, and others. Who could be a more important witness than Hunter Biden? And then to suggest that there's nothing prompting this inquiry is ridiculous. The record contains witness and written evidence that the president has lied about key facts in foreign dealings, was the focus of multi-million-dollar influence peddling schemes, and may have benefited from this corruption through millions of dollars sent to his family, as well as more direct and possible benefits. The current allegations contain an alleged effort to sell influence or access, as well as other wrongdoing. Corruption allegations involving a president are particularly damaging for our political system. They effectively dissolve the public trust in government. Self-dealing and influence peddling and obstruction all undermine the faith that federal laws are being enforced equally. So for this amendment to be offered to suggest that there's no link between the president and this type of conduct is ridiculous. The public is often skeptical of the ability or inclination of federal agencies to investigate allegations raised in relation to a sitting president. So the assertion by ranking member that special counsel has been appointed to look into this, the public does not believe that that will occur. Current polling illuminates the deep distrust by the public in this kind of effort. Roughly half of the public does not have faith that the Justice Department investigation into the Biden administration would be fair or nonpartisan. And polls further indicate half of Americans also believe President Biden broke the law in relation to his son's business activities. So again, the amendment is not well taken. One other thing, Mr. Chair, I want to mention, as an attorney who's taken dozens, if not hundreds of depositions, I understand exactly why we need a deposition and not an appearance by Mr. Hunter Biden before this committee. Look at this committee. Look how it approaches things. This is no way to get to the facts. 5 minutes here, 5 minutes there, and then each time after you finally get to a point, someone on the other side rushes in to try to obfuscate and confuse the issue. That's why you do depositions, to get to the point and to have the time to do it and not be burdened by how this committee operates. And I would just say there's a huge reason to do exactly what we're doing, and that is get to the bottom of the facts that would address the years and years and millions that Hunter Biden has spent selling influence. And who would Hunter Biden sell influence about or to? Who? Well, it would have to be his father. There's no one else in his circle of friends that would warrant such investment by outside influencers. Mr. Chair, I could obviously go on, but I will just suggest that the deposition is the proper approach. His refusal to appear for a deposition and then say he would put himself at the mercy of this committee is ridiculous, and he deserves to be held in contempt. And with that, I yield back.
Gentleman yields back.
Mr. Chairman?
On the amendment, Mr. Ranking Member?
Yes.
The gentleman is recognized on the amendment, and then we'll go to Ms. Dean.
Thank you, Mr. Chairman. Let me begin by assuring Mr. Bentz that the Democrats on this committee would be perfectly happy to have the rules of a deposition, 45 minutes or whatever it is, an hour of interview by one party and then by the other, apply in public in this committee, so that the gentleman's objections about 5 minutes would not apply. We do not want, and Mr. Biden properly does not want, a private deposition, because we've seen, as I said before, that the Republicans have quoted improperly and from the private remarks, and have distorted what they said by quoting half a sentence here and half a sentence there. This amendment notes that House Republicans are continuing to harp on an investigation. And let me just say one other thing. The fact that half of Americans may believe one thing or another proves nothing other than the effectiveness of propaganda by one party or the other. It has nothing to do with the truth of the matter. This amendment notes that House Republicans are continuing to harp on an investigation that has produced no evidence of wrongdoing. Despite more than 37,000 pages of documents the majority obtained, and despite interviewing more than a dozen witnesses, Chairman Jordan and committee Republicans have yet to produce a single shred of evidence that suggesting that President Biden engaged in any wrongdoing whatsoever. In particular, the congressional Republicans have received tens of thousands of pages of bank records, including the personal bank accounts of Biden family members and other private citizens. Republicans' claims about the president's supposed wrongdoing are not supported by the evidence. Not one witness has testified that President Biden personally benefited from Hunter Biden's business dealings. Republicans have claimed that a check from Hunter Biden to Joe Biden is somehow proof of foreign corruption. But the evidence actually shows that Hunter Biden repaid his dad for a car loan. That doesn't need to be the subject of a congressional investigation. There's also no evidence that President Biden interfered in the criminal investigation of his son. In fact, the witnesses who have been working on the investigation have all affirmed to the committee that there was no political interference. The committees have uncovered no evidence that Joe Biden profited from his son's business dealings or that he interfered in the criminal investigation of his son. No evidence whatsoever, and that's why it's one of the many reasons why this committee motion to hold Hunter Biden in contempt, given the fact that he is willing to testify and has offered to testify repeatedly, is a farce and ought to be defeated. I yield back. I yield to Ms. Jackson. I yield to Ms. Jackson Lee.
Gentleman yields. Gentleman from Texas recognized.
Let me express my appreciation to Mr. Nadler and to Congresswoman Dean. I was going to wait till afterward, but I'll take my time now very briefly and simply say that we've had every agency. I want to read in particular the work of the Treasury Department that has produced more than 2,000 pages of suspicious activity reports, SARS. The National Archives and Records Administration has produced more than 62,000 pages of Vice President Biden's records on top of more than 20,000 pages it already made publicly available. And the Federal Bureau of Investigation provided access to and multiple briefings regarding a Form FD 1023 tip sheet, which contains sensitive information about a confidential human source. We have offered when I say we, the Democratic administration that believes in transparency has offered every aspect of what we could present to tell the truth. The truth is not being told here as relates to holding Mr. Biden in contempt. The truth is not being told because the facts evidence there is no basis for doing so. And if I might conclude, there is no basis for any form of impeachment against President Biden. There are no high crimes and misdemeanor. There is no treason, and every aspect of the government has, without in any way bias, presented this to committees of oversight and the judiciary. It seems that every time our friends on the other side of the aisle get in trouble and have no legislation to deal with the insulin $30, the Affordable Care Act, environmental crisis that we may be in, helping with inflation, which we've done, they throw out impeachment, just as the frivolous call for the impeachment of General Austin. Can we do something that helps the American people? My amendment should be passed because there's no evidence, Mr. Chairman, to move forward at all. I yield back.
I yield back.
The gentleman yields back. The chair recognizes himself to speak against the amendment. The amendment would delete a number of important sections of the report. Specifically, I want to reference the report about the Biden's interaction with this Ukrainian energy company, Burisma. Both the ranking member and the gentlelady from Texas said there was no evidence. Let me give you some evidence. It's called the 1023 form that the confidential human source gave to the FBI that they recorded in this form. Remember the facts here. Hunter Biden is asked by the people, the head of Burisma, this Ukrainian energy company, to weigh in on their behalf to relieve the pressure that the prosecutor in Ukraine is applying to the company. They're doing that because they want to do a big IPO offering and expand their business. He's asked to weigh in. He immediately calls D.C. Mr. Archer, when he testified, said he actually called, one time he said he called Vice President Biden. Here's what the confidential human source related in the 1023 form, again, that the FBI tried to keep from us, but we finally got. They meaning Burisma, hired Hunter Biden to, quote, protect us through his dad from all kinds of problems. Now, this is the confidential human source, by the way. In one of these 90 different depositions and interviews we have done in this committee, Scott Brady, U.S. Attorney in Pittsburgh, said, U.S. Attorney in Pittsburgh, tasked by the Justice Department to evaluate information regarding Burisma, the Bidens, and Ukraine, said, we found this confidential human source to be credible. In fact, he said in that deposition, we looked at where he was and his schedule when these meetings took place and found that he was in those locations meeting with these people. So they checked him out and found him to be credible. And here's what the confidential human source further said in this document that the FBI recorded. Due to Shokin's investigation into Burisma, it would have substantial negative impact on Burisma's prospective IPO in the United States. It'd be problematic to raise capital, given in Shokin's investigation into Burisma. Again, Shokin is the guy Joe Biden fired. And how did he do it? How did he do it? He leveraged American tax dollars. He says, you're not getting the money unless you fire the guy. He did this 3 days after his son calls him at the request of Zlochevsky, the guy who's talking to the confidential human source who the FBI recorded in this form that the FBI didn't want to give us. And that's the section that the gentlelady from Texas wants removed from the report. Now, why would that be? Why would she want to remove that section? That seems to be the heart of the matter. Politician taking actions that benefit his family financially and using American tax dollars to accomplish that end. Again, not Jim Jordan saying it. We have Joe Biden saying it. He said it on tape. I told the government there, you want the money? Fire the prosecutor. Now we know why he wanted him fired, because the confidential human source told us. Again, why we couldn't see this, why we had to push so hard to finally get this information, I don't know. But what I do know is the confidential human source understood that Zlochevsky had already paid the Bidens to, quote, deal with Shokin. His words, not mine. I would yield the balance of my time to the gentleman from North Carolina.
I think the chairman and my thoughts went to the exact same place. The gentlelady from Texas in offering the amendment, in fact, in the amendment it says, furthermore, to the extent that the Judiciary Committee has been investigating the Department of Justice's handling of the Hunter Biden criminal matter, the evidence has shown that the department has handled this investigation apolitically in accordance with all relevant statutes, guidelines, and policies. She said she was embarrassed by this hearing, but she's not embarrassed by offering that language. That's remarkable on its own. But as to the 1023, they say there's no evidence. The CHS, who, as the chairman says, has been termed credible by the FBI and by the United States Attorney from Pittsburgh, he says that the CHS said that Zlochevsky said it cost $5 million to pay one Biden and $5 million to pay to another Biden, and that he was furthermore to suggest that was Hunter and Joe. Ladies and gentlemen, that's direct evidence of a bribe. Now, you'd say it's hearsay. In fact, it sounds like double hearsay at first, because you got the CHS. We don't know who that is, and he's not testifying in court. And then you got Zlochevsky being the declarant, the person who said it. But that'd be subject to a hearsay exception. He's a conspirator with the Bidens under the evidence that he's offering right there. And it would be admissible in a court of law if the CHS was testifying. So I'd yield to anybody on the Democrat side, on the minority, or anybody on the committee who can tell us, who is the CHS? I want to know who the CHS is. Who's the confidential human source? There's no evidence? Let's look and see if there's evidence.
The gentleman yield?
Yes.
Mr. Bishop, you've answered your own question.
The time has expired. Maybe we can get, we're happy to continue this debate because we think it's so obvious. I appreciate the gentleman's point. I think it's the gentlelady from Pennsylvania, Ms. Dean, is recognized. And
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
I rise in support of the amendment offered by Ms. Jackson-Lee, and before my remarks, I'd like to yield to the ranking member.
I thank the gentlelady. I just want to point out, when the Republicans talk about the 1023 form, we should have a member, the fact of the matter is that the person who provided the 1023 said in the 1023 that he didn't know if it was true. So we cannot rely on anything in the 1023 because the person who provided it said he had no idea whether it was true or not. I thank the gentlelady. I yield back to her.
Gentleman yield? Or gentlelady yield?
It is my time.
Yes, I know. You don't want to yield. Okay, I'll be glad to answer that, though.
Thank you. As I said, I rise in support of the Jackson-Lee amendment because it is all about the evidence. Let's think about the evidence. It has been 608 days since Chairman Jordan received his own congressional subpoena. He has yet to comply. A subpoena simply saying, come and tell us what you know about the events surrounding January 6th, the lead up to it, your conversations with the president during it and after it. Come forward, reveal anything you know. The chairman should never have needed a subpoena to do exactly that. That is his duty as a citizen, as a member of this Congress, as someone who was here at the time of the insurrection incited by a former president. And yet they're searching, they're struggling, they're wishing they could find some evidence here that would connect Hunter Biden to Joe Biden. There's no evidence. It's one thing to demand legitimate congressional inquiries be met by cooperation, of course. Mr. Biden has agreed to cooperate in a public setting, right here. You could have him whenever you want, where his words could not be manipulated. It is another thing entirely to say there are rules for thee, but not for me. That's exactly what we have here. It's sad to say this is yet another pathetic political stunt designed to help Donald Trump. But maybe they watched yesterday what happened in the D.C. Circuit Court as the former president sought immunity, even in the case of killing a political opponent or ordering the killing of a political opponent. Think of the absurdity of where we are because of Donald Trump and those who follow him, like a lot of members on this committee. Instead of helping Americans who are hurting, for example, already this year, there have been more than 900 gun deaths in the United States. Every day we lose a jetliner worth of Americans to deadly drug poisoning and overdoses. We've got democracies to support, including our own. And yet the Republican majority can't pull itself together to do any of that. Second, in interview after interview, deposition after deposition, and the Biden impeachment inquiry has yet to turn up legitimate evidence of any wrongdoing of the president. Zero, nothing, and they have supplied thousands, tens of thousands of documents. At the same time, a report by the Oversight Committee has found evidence that Donald Trump violated the Constitution, the emoluments clause of the Constitution, at least 7.8 million times. A few findings from that report bear repeating. President Trump called the presidency, quote, the greatest infomercial in political history. Donald Trump certainly knew how to work that infomercial to his personal advantage. The report reveals in just 2 years of his 4 years as president, he took at least $7.8 million in unconstitutional payments from 20 foreign countries to just 4 of his hotels. We don't know about the hundreds of other entities. Did Donald Trump seek congressional approval for these funds, as the Constitution requires? Of course not. In fact, Mr. Trump attempted to conceal his enrichment. Worst of all, 7.8 million is likely a gross underestimate. We still have no idea the full extent of his wrongdoing and that of his close family members. We only have information regarding 2 years and only 4 hotel properties. Can we all agree that these findings are shocking, sickening, unconstitutional, in violation of the Emoluments Clause, which simply says, Article 1, Section 9, Clause 8, forbids the president to accept money or payments or gifts of any kind from foreign governments, monarchs, unless he obtains consent from Congress. None of that happened. And yet, oh, the outrage about Hunter Biden. Mr. Chairman and your entire committee, where is your investigative spirit? Selling influence? You've shown no interest in looking at what the president, the former president, did in selling his interests. It's in a desperate attempt to rehabilitate their leader. Republicans are trying to pin Donald Trump's misdeeds on President Biden. There's a word for that. Desperation. No, actually, it's projection. I yield back.
Gentleman yields back. The gentleman from Texas is recognized.
Thank you, Mr. Chairman. So this markup, it's about Hunter Biden. It's not about President Trump. I keep hearing my colleagues on the left talk about President Trump and that no one is above the law, and I keep hearing this argument ad infinitum. I guess what they mean is that no one is above the law except for when it comes to President Biden's son, Hunter. And Hunter Biden should not be given special treatment. He defied congressional subpoena and should be treated like others who have done the same, plain and simple. See, Hunter should not be treated with kid gloves. This man is 50 years old, literally. It's a grown-ass man. Congressional Democrats held Steve Bannon and Peter Navarro in contempt of Congress for not complying with congressional subpoenas concerning an investigation to January 6th. Hunter had every right to appear and plead the Fifth, and he chose to defy the subpoena when he instead held a self-serving press conference right at the steps of this building. When Democrats issued subpoenas to Republicans during the House January 6th investigation, President Biden said, and I quote, I hope that the committee goes after them and holds them accountable criminally, end quote. Okay, all right. Now let's do Hunter, and that's why we're here. Hunter Biden makes arguments of passion to excuse his behavior. His best defense is oftentimes to make the public feel sorry for him. That's right, we should feel badly for him because he personally enriched himself because of his last name. And again, the left wants us to treat him with kid gloves, and this man is 50 years old. Please, your daddy's saving you at this point. It ain't gonna work here anymore. He should not be given special treatment because he thinks he's an American prince. And I don't mean Purple Rain. A witness does not get to decide his preferred method of appearing before the committee. The committee that subpoenaed the witness does. That's how this place works. House committees are not in the business of letting witnesses dictate to us the type of depositions or hearings that they want to have. This is not a kangaroo court like President Trump is seeing in the New York trial. It's up to the committees to determine the best methods that will further their investigation, and rather that be through deposition, transcribed interview, or public hearing. This is our job to do that, and Hunter Biden does not get to dictate that to us. And with that, I yield back the rest of my time. Thank you, Mr. Chairman. The gentleman will yield.
I appreciate the gentleman yielding. I just want to respond to the ranking member's statement about the confidential human source. He said something to the effect that confidential human source didn't know if the statements he received from the chief executive Burisma were accurate or not. But here's what he said in the document that the FBI recorded. The confidential human source did not perceive Pajarski or Zolochevsky's statements to be unusual, self-serving, or pretextual. In other words, he thought they were accurate. He didn't know for sure, but he thought they were. That's why he said that. That's why the FBI recorded it. And this FD 1023 form that, again, they tried to keep from the U.S. Attorney, Mr. Brady, who was supposed to be gathering this information, sending it to the appropriate U.S. attorneys to investigate. In fact, they try to keep it from him. The things that are said in here, I think, are so powerful. And frankly, this was supposed to be, David Weiss was supposed to use this when he was doing his investigation. But instead, David Weiss decides to let the tax years where Hunter Biden owed so much money, just let the statute of limitations lapse for those years when it dealt with the Burisma income. So I appreciate the gentleman yielding.
Gentleman from Texas, yield the balance of your time. I thank you very much. So to the chairman's point, this 1023 is the mother of all corroborating evidence. It tells from the other side what the circumstantial evidence already indicates about the payment of money for Hunter Biden on this board for which he did nothing. The Devin Archer thing about calling Washington. The fact that Joe Biden made the audible on the airplane flying about holding the money to force the firing of Shokin, the prosecutor that Burisma, that Zlochevsky, and didn't want to get rid of, didn't want to see, he wanted him gone because he was worried about being protected. And the phrase that you just read, Mr. Chairman, is saying, the CHS is saying, I wasn't involved in this stuff, so I don't know. But he seemed credible when he was telling me he bribed Joe and Hunter Biden.
Yep.
All right, expired the time.
Gentleman, Texas yields back. The chair now recognizes.
Mr. Chairman?
The gentleman from California is recognized on the amendment.
Happy to yield to the gentleman from Texas, Sheila Jackson-Lee.
I thank the gentleman from California, and this is to emphasize to the multiple gentle persons across the aisle that my amendment, the Jackson Amendment, has much merit because it is based on the fact that you have no facts and you have no truth. Isn't it interesting that we would rely upon two nations, Ukraine and Russia, Ukraine previously under the dominance of Russia, despotic leadership until they broke free, seeking a level of democracy, pleading for them to be able to be a nation that welcomes the values of equality and justice and the management of laws so that there is fairness. But yet my friends are trying to dismiss my amendment, which is solely suggesting that you have no facts, on what happens in countries like Russia. They constantly do confidential or covert recordings. They constantly do that. They have no basis in what the person is saying is true or not. No knowledge of the veracity of what is said, but they're going around recording everyone, called confidential human source. And so the confidential human source that is being relied upon by the Republicans met Zlochevsky in person on one occasion and has spoken to him only twice on the telephone. As such, the confidential human source is not able to provide any further opinion as to the veracity of Zlochevsky's aforementioned statements. Of course, my amendment should be voted on and accepted because President Biden has been proven over and over again he had nothing to do with Burisma, nothing. So to respond to all of those who are trying to cite a confidential human source, it is of no value. It is like pouring a water into a pot full of holes. When you get through, you have nothing. We don't have anything. And so I would ask my colleagues to support the Jackson Lee Amendment, which indicates that with all of the thousands of pages from the Treasury Department, from the FBI, IRS, all these agencies, the White House willingness to be open and to present themselves forward, there is no reason to proceed as we are proceeding. Ask my colleagues to support the Jackson Lee Amendment.
Gentlelady yields.
I yield back to the gentleman.
Gentleman from California yields back. Gentleman from Arizona is recognized. Mr. Biggs.
Move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. So, having attended the deposition of Devin Archer, and there were only 3 members of Congress in that deposition, the chairman, Mr. Jordan, myself, Mr. Goldman from the Democrat side. And what I find interesting is that this amendment is moving to strike all of this very important information which demonstrates a criminal conspiracy on the part of the president. So I asked questions. Mr. Jordan did, Mr. Goldman did. And of course, who was the brand that Devin Archer, Hunter Biden, and his Rob Walker, that partnership, what was the brand they were selling? It was Joe Biden. He admitted it. Well, could it be anybody else in the Biden family? No, we were selling Joe Biden. We were. That's what we were doing. So you begin talking, there's money that goes on. You see Joe Biden is involved in the business. He's making phone calls. He's making appearances. Money is coming in and exchanging hands. Shortly after phone calls, shortly after Joe Biden goes to a restaurant to meet with the wife of the former mayor of Moscow, one of the biggest oligarchs in Russia, $3.5 million right into the Biden coffers. They're receiving literally millions of dollars, all linked to this. So we say, well, my friends across the aisle say, well, there's no evidence here. There's nothing here to be seen. But Devin Archer was testifying to that. There are other witnesses that I don't think you've paid attention to who've also said Joe Biden was the brand. He was the product they were selling. Yeah, so you got that on one side. So the question is, can that be corroborated? Then you get a 1023. By the way, the FBI should give us the underlying 1023, which explains why they went ahead with this 1023. Now, the chairman, yeah, there was another 1023, which
Nobody's told me that yet.
Yes, there was. And it's why they went ahead with this interview. So great minds think alike, I guess. I actually underlined the same provisions that the chairman did. The former president or prime minister of Poland and Joe Biden's son, Hunter Biden, Wojcicki said Burisma hired the former president or prime minister of Poland. So you get the prime minister of Poland's hired to leverage what? The EU folks. But what was Hunter hired for? To, quote, protect us through his dad from all kinds of problems, close quote. And I won't go through the rest of this, but because it also corroborates what Devin Archer was talking about. Hunter Biden's dad was the product, and what was he expected to do? He was expected to do things like was explained in here by a reliable source, to take care of Victor Shulkin. So what else did Devin Archer talk about? He's in Dubai with Hunter Biden. They're at that sailboat typey hotel. They're there, and they're with the president and CEO of Burisma, as well as the treasurer of Burisma. And what are they talking about? Oh my gosh, we're having trouble getting our IPO out because Victor Shulkin, the AG in Ukraine, is basically going after them. Devin Archer says they excused themselves, and Hunter goes and calls his dad because that's what the CEO of Burisma said, please do. We need help from your dad. We have a recess, they come back. Well, you know, maybe it was just to DC. What confirms that? The 1023. Don't say there's no corroborating evidence implicating Joe Biden. It's all in this 1023 and Devin Archer's testimony, and then you start using all the other documentation to show very clearly a criminal conspiracy of bribery and selling access on the part of the Biden family. I'll yield to the gentleman from North Carolina.
I thank the gentleman from Arizona. And I'm struck, and maybe I'm going to maybe get a chance in a minute, but the continued contention that there's no evidence because the CHS doesn't know whether what Zlochevsky and Prigozhin said was true or not, even though they seemed credible. That's not how this works. Unfortunately, I'm out of time. I'll explain it in a minute, but we got my truth, your truth. We really don't have differing definitions of evidence. It means something, and we'll talk about that.
The gentleman's time has expired from Arizona. The gentleman from North Carolina is recognized for 5 minutes on the amendment, and then we'll have the vote on the amendment.
Thank you, Mr. Chairman. So let's talk about that just a little bit more. Evidence, this is not, actually everybody thinks this is going to sound lawyerly, but it's just very straightforward. Evidence is anything that comes within the rules of admissibility that tends to make any matter, any proposition, more probable or less probable, meaning that it has probative force, tends to prove one way or the other. And they have all these rules in evidence about when somebody who's not in court and says something that was said out of court wants to testify about that, when that can be allowed. And here we have what's called, it looks like preliminarily a double hearsay problem. The CHS is not here testifying, and Prigozhin and Zlochevsky, the guys who say they paid a bribe, certainly aren't here. But what this is a situation, let me give you a hypothetical, slightly different situation. Let's assume it's not the confidential human source, or the confidential human source isn't having a conversation with Prigozhin and Zlochevsky, but he's somewhere nearby, and he hears them talking. He eavesdrops on them, and they're talking about having paid bribes to Hunter Biden and Joe Biden of $5 million each. Now, in that situation also, the person in the position of the CHS, the eavesdropper, would not know whether Zlochevsky and Prigozhin are being truthful or not in saying they paid bribes, but that does not mean it is not evidence. It is evidence. And it comes in through the hearsay rules because those people are describing a criminal conspiracy. The statements of a co-conspirator are so-called admissions of a party opponent. They come in through that rule. This is straight up direct evidence of bribery. Now, you can say, if you want to, that you're not persuaded by the direct evidence, the person admitting that they committed a bribe or undertook a bribery scheme, but it's not that it's not evidence. So you could say, well, I think there's evidence, and it's admissible evidence, and a jury would be well-founded deciding on the basis of that evidence to convict for bribery, but I'm not going to do an investigation anyway. I'm not going to support bringing in the witness who is defying the subpoena of the Congress because I'm just not persuaded by that direct evidence of bribery. I understand that would be a contention you can make. But again, even in this age when you talk about, I want you to tell your truth and I'm going to tell my truth, which is abysmal and absurd on its face, I didn't know that we had started changing the definition of evidence. But there is evidence. And even to those people who say, well, it sounds like it's circumstantial evidence and indirect evidence. Well, by the way, lots of people were convicted on circumstantial and indirect evidence. But that's not the case either here. When the bribery conspirator is overheard or is heard saying, I engaged in a bribe with that person, that's direct evidence of bribery. And so, I'm, in terms of credibility, again, I'd love to evaluate the confidential human source. I think the country ought to get the chance to evaluate the confidential human source in this case. It's that important. But if you want to say, and again, what's in the FBI and the United States Attorney have both evaluated him, they tell us, and they say this confidential human source is credible. So if he were in the situation of being an eavesdropper, that means he really did what he says he really heard what he says he heard. So some people won't be satisfied no matter what evidence is offered, and that's clear. But there's lots of evidence. And with that, I'd like to yield to the gentleman from New Jersey, Mr. Van Drew.
I thank the gentleman from North Carolina. I wanted to reference a remark made by my colleague, the gentlelady from Ms. Dean. She says she's worried about guns, and we need more gun legislation. I'm worried about guns too, but we don't need more gun legislation on legal gun owners. But we do need to address issues like Hunter Biden, and we need to prosecute people like that who criminally falsify an application for a gun. These aren't talking points, this is the truth. Who criminally was drunk and high while purchasing said weapons, who criminally and illegally disposed of guns and was to be exonerated in a special plea deal. Talk about justice not being fair for everyone. God help anybody who did that who wasn't the president's son. That's what I worry about, and that's what Americans worry about. I yield back.
Gentlemen, time has expired. The question occurs on the amendment from the gentlelady from Texas. All those in favor say aye. Aye. All those opposed, no. No. In the opinion of the chairs, the noes have it. A roll call being requested. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Buck? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Spartz? Ms. Spartz votes no. Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivey? Ms. Ballant? Ms. Ballant votes aye.
McClintock, no.
Mr. McClintock votes no. Mr. Gates votes no.
Does anyone else wish to record their vote? Clerk will report.
Mr. Chairman, there are 8 ayes and 15 noes.
The amendment is not agreed to. You got an amendment? Oh, okay. Gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report. Gentleman from Arizona reserves.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find Robert
Objection. The amendment will be considered as read. The gentlelady is recognized to explain her amendment.
Thank you, Mr. Chairman. This amendment would add to the scope of the report's investigation what the majority says is necessary to inform our legislative work. For example, finding examples of possible enrichment of president's family members. I believe it's worth reading my brief amendment because I'm pretty sure you're all going to be convinced we should add this. On page 10, insert after the sentence beginning Mr. Biden's deposition is critical. Add the following. The committee also intends to investigate former President Trump's son-in-law and senior advisor, Jared Kushner. In particular, the committee must understand Jared Kushner's receipt of $2 billion from the Saudi Arabian government for his private equity firm just 6 months after leaving the White House, as these relationships were fostered during his tenure as a public official with a top security clearance while he worked for his father-in-law, former President Trump, on the issues relating to the Middle East. It is imperative for the committee to investigate his actions and role. In particular, the committee must understand if Jared Kushner leveraged his relationship with his father-in-law to secure large payments from foreign governments. Doing so would allow the committee to shape effective and targeted legislation and solutions that would expose and thus hopefully deter attempts at influence peddling by similarly situated family members, including activities that could jeopardize national security. Specifically, it would include the $2 billion that former senior advisor to President Trump, Jared Kushner, he served from 2017 until 2021 in the White House, his private equity firm received from a fund managed by Saudi Arabian Crown Prince, often called MBS. These payments are detailed in the recent report released by House Oversight Democrats led by Mr. Raskin, which found that former President Donald Trump violated our Constitution repeatedly while in office, placing himself and his financial interests above the law. To quote just a moment in the report, quote, Jared Kushner has also richly monetized his business ties with Saudi Arabia, reportedly with the direct assistance of MBS. The day after his service in the Trump administration ended, Mr. Kushner formed a company that became a private equity firm called Affinities Partners, aptly named. And within 6 months after leaving the White House, Mr. Kushner secured an investment reportedly worth $2 billion from Saudi Arabia's sovereign wealth fund, end quote. Of course, the $2 billion investment in Kushner's firm is separate from the more than $615,000 in unconstitutional emoluments received from Saudi Arabia during the Trump presidency. The total the former president likely received is far more than what the report uncovers and documents and proves. $7.8 million from at least 20 different companies during his time in office. That's just 2 years, by the way, of this report, and just 4 of his hotels, not the other hundreds of business entities. You know, I agree with the majority on one thing. Our laws should deter foreign interests from attempting to obtain influence over and access to the highest levels of federal government, end quote. Absolutely. If my colleagues are truly interested in strengthening our safeguards against undue foreign influence and not just benefiting Donald Trump, I have no doubt, Mr. Chairman, that this amendment will pass. In the meantime, I seek unanimous consent to enter into the record the report entitled White House for Sale, How Princes, Prime Ministers, and Premiers Paid Off President Trump.
Objection.
I also seek unanimous consent to enter into the record this article entitled Oversight, Democrats release report proving Trump pocketed millions from at least 20 foreign governments as president.
Without objection.
Mr. Chairman, I am so looking forward to unanimous support. After all, Jared Kushner was not a private citizen. He served in the White House for 4 years as senior advisor to a sitting president. All as the sitting president, his businesses and his families enjoyed violations of the Emoluments Clause, millions of dollars pouring into their own pockets. And one day after he leaves the White House service, Mr. Kushner begins Affinity Partners, and 6 months later has $2 billion in the account from Saudi Arabia. I yield back.
Gentlelady yields back. Does the gentleman insist, the gentleman withdraws his point of order? I would just point out that this markup's about a report on contempt for Mr. Biden, not anything to do with Mr. Kushner. And I would also just say, I think in the gentlelady's amendment, the last line talks about things that could potentially jeopardize national security. Jared Kushner was one of the people who helped secure the Abraham Accords, which I think focused on peace and agreements and helping the Middle East. And frankly, what a contrast in the Trump administration with the Biden administration. I love the question former Secretary of State Mike Pompeo got when shortly after Russia invades Ukraine, he was asked, would this have happened in a Trump administration? I thought the former secretary gave the best answer. He said, the short answer is I don't know, but I do know this, it didn't happen in a Trump administration. And our best friend, dear friend, the state of Israel was not attacked in the Trump administration like they were a little over 3 months ago. Jared Kushner did great work, and to have this amendment makes absolutely no sense. So I would urge that the amendment be defeated. I would yield to the gentleman from Wisconsin, and then I'll recognize the ranking member.
Thank you, Mr. Chairman. To the author of the amendment, may I pose a question to you? So do you have specific language around this? So the allegation is in regards to Jared Kushner. Do you have specific language around this to highlight how this is inappropriate and what we can do to create a bill that will deal with this? Is that included here at all?
The point is to say exactly that. We should investigate exactly the facts. We know the dates, we know the facts, we know the dollars. We know Jared Kushner's public service in the closest levels to the President of the United States. And as he walks out the door, he begins a business that later gets $2 billion from a foreign entity. All the while, during the administration pocketing millions and millions of dollars. I wonder, where was your outrage then? Where was your investigation then? When we saw in plain sight the President of the United States, right down the street here at Trump International, take in millions of dollars from foreign entities. That puts
I'll reclaim my time. I'll reclaim my time. Thank you for that. We clearly did not get an answer there about specific language, so it was meant as just another hit piece here to try to obfuscate and not deal with the issue at hand, which is getting Hunter Biden here to fulfill a subpoena, right? I mean, that's ultimately what's happening, and you see this sleight of hand that's going on. But I will read from the 1023 document. Hunter Biden was stupid, and his dog, this would be Zlotowski's, was smarter. Therein lies the difference between Jared Kushner and Hunter Biden. Hunter Biden didn't know how to run a business. Jared Kushner actually does. He knows how to finance a business. He knows how to operate successful businesses. That's the difference here. Mr. Chairman, I'll yield any time that you may want.
Yeah, I thank you for yielding. I would just ask the question, does anyone remember Hunter Biden going over to China, to Beijing in Air Force Two, and while his father was conducting official business, was meeting with business and potential business partners, and within a matter of a few months after returning, he received equity fund management in the amount of billions of dollars. Anyone else recall that, or is it just me? That is a true story, and I'm curious about the outrage by my colleagues across the aisle. I'll yield back to you, Mr. Tiffany.
I would yield to anyone else that cares for time. I yield back, Mr. Chairman.
Gentleman yields. Chair recognizes the ranking member, Mr. Nadler.
Thank you, Mr. Chairman. I have several comments. First of all, we don't actually know that Jared Kushner knows how to run a business. All we know is that after dealing with the Saudi Arabians from the White House, he got $2 billion. We don't know whether he knows how to run a business well or not. Number two, when you quote from that 1023, don't forget that the person who offered the 1023 said, I don't know whether this is true. The person who offered the 1023 said, I don't know whether this is true. So you can't depend on anything in that 1023. Third, as we said before, Hunter Biden has offered to testify before this committee. This committee has turned him down. He's offered to testify in public. He can do it under the same rules as a deposition, but he doesn't want his remarks to be cherry-picked and distorted for public release. And given the record of this committee, I don't blame him. 90 people have come in for transcribed interviews. The full text has been released for exactly one of them. The others have been selectively released, and we know some of that has been distorted with half sentences released and the other half sentence not released. For the committee to fully understand the scope of the issues that a report or legislation would respond to, the report must include examples of possible enrichment of President's family members, including Trump's son-in-law and former senior advisor Jared Kushner. And we know, by the way, that he was denied security clearance to become senior advisor, but that the president personally overruled that. Kushner's firm received $2 billion from illicit connections in the Middle East for his private equity firm, thanks to relationships he fostered while acting as a public official with a top security clearance on issues related to the region. This $2 billion investment came from a Saudi fund led by the Crown Prince. This investment accounts for the majority of Kushner's funds, approximately $3 billion in holdings, and raises very substantial concerns as to whether there was any form of quid pro quo for his funding secured during Kushner's term in the White House. In addition, as I said, Kushner's security clearance approval was fraught with controversy. In fact, it was not just fraught with controversy. It was disallowed until overruled by the president. And Kushner advocated heavily for Saudi Arabian interests when he was a policy advisor to the then president. And if we're going to have a balanced resolution, we should include this as well as the Hunter Biden thing. And let me mention one other thing. There was a special prosecutor appointed by Merrick Garland to deal with Hunter Biden. Hunter Biden may very well have committed crimes. I don't know. I hold no brief for him. But Hunter Biden is not an elected official. And there's been not one iota of evidence that anything that Hunter Biden did benefited the president or that the president was involved in any way, which is the only legitimate concern for this committee, whether the president was involved. And after all the investigations, there is not one iota of evidence that the president was involved in any way. I yield back. I'll yield to the gentleman from Tennessee.
Thank you. I heard some talk. It was kind of, I guess, just off the cuff, but it was about Hunter Biden's business experience and abilities compared to Jared Kushner's. 666 Fifth Avenue, which Jared Kushner bought at the height of the real estate boom, and then was saved when it was about to go broke by, I think, the Gutteries, who gave him the money in some type of transaction to save the building, was considered, I believe, Mr. Nadler, to be one of the worst real estate deals ever in the city of New York. Were you aware of that 666 Fifth Avenue deal?
I'm aware of that deal. It's in my district.
Yeah, 666. It's interesting, the numbers. And then he bought the New York Observer and bought it at a high price and sold it at just about a nothing price, garbage price, and he basically ruined that paper too. So I would submit without any particular regard or endorsement of Mr. Biden's business abilities, I think he's equal to Jared Kushner's. Yield back.
And I yield back.
Gentleman yields. Chair recognizes Mr. Issa, the gentleman from California.
I thank the chairman. Amazing how we've now digressed into whether somebody's a good businessman or not. I would assert that this is not the committee likely to make that decision particularly well. I also would assert that the personal financial statements of Jared Kushner are available online because he did file them. And when I looked at him, I recognized at a minimum that he is wealthy. I'm not going to argue whether someone's a successful businessman or whether a particular acquisition was made at the height of the market or the bottom of the market. That all sounds pretty irrelevant, particularly considering that, once again, they want to bring somebody for whom there has been no referral, for whom there was not a subpoena from this committee that was thwarted. We have one individual who did not answer the subpoena, but rather showed up up the other side of the Capitol, deliberately flipping, as I said earlier, the middle finger at the American people. And we are here today to hold that man in contempt. The hope is that when faced with the criminal contempt and the possibility of incarceration, not for the crimes that apparently he's already pled to, but in fact for yet another crime, not answering the subpoena, that he just might come and answer our questions honestly. Many on the other side of the aisle are saying, well, there's no evidence, there's no evidence. Well, I've got to tell you, I've never heard that you have to have all the evidence before you ask the questions in an investigation. What we have is an individual who goes and does business deals, and then those business deals affect the policies of the vice president, so much so that the vice president had one policy when he got on an airplane on the way to Ukraine relative to the prosecutor, a prosecutor that was going after Hunter Biden's business partners. And by the time he got off, his policy became, Ukraine gets none of the funding from America until you fire this prosecutor. And by the way, the vice president has taken credit for it. It's not debatable. So when we have the opportunity to ask Hunter Biden questions, those questions will include, what did you say to your father? A man who said he had no business dealings with his son, had no financial interest. As a matter of fact, he said about 5 different things. They keep changing. The one thing we know is he did have conversations and texts that included what Hunter Biden's businesses were doing. Funds did come to the residence of the vice president, and in fact, Hunter Biden also had accounts which were joint with the vice president. If Hunter Biden was selling preferences, as he clearly was, he was very publicly in China, in Ukraine, in Russia, he was selling, my business has the access to the White House, in that case, to the executive office of the vice president. He was selling it. If he was selling it and he didn't have it, come and say that. If it was all just a fraud to get money from foreign governments, come and say that. But when we see him taking money and we see actions of the vice president changing on a dime in a direction of his son's needs, we have a legitimate right to ask Hunter Biden to come here. We have done so. He declined. We subpoenaed him. He did not decline, but rather offered to have a staged public event, and the chairman, rightfully so, said, we would like to have 4, 6, 8 hours of no theatrics, just question and answer. Rather than saying he wouldn't come, we sat here waiting for him to come. Well, he had a theatric activity on the other side of the dome where he had a staged press conference where we sat here seriously waiting for a deposition. That is why we are here for contempt. Don't be confused by statements of who is a good business person or not, who has done well financially or not, who these allegations of gain by the president or his former president or his family. That's not an issue here today. If you want to have that at issue, bring a motion. But right now, we have a motion in front of us, and I look forward to the vote on the motion, and I yield back.
Gentleman yields back. Gentleman from Maryland on the amendment.
Thank you, Mr. Chairman. Just briefly, before I yield, I did want to say the issue about who was a good business person was raised by the Republicans, not us. So if you don't want it to come up, your side shouldn't bring it up. With respect to this bad prosecutor issue of getting the prosecutor fired, I think that's been, repeatedly debunked, that this was an individual who not only did, the United States want him fired, but was internationally, there was a desire to get rid of him because he wasn't doing his job, and made it more, the replacement of him with an actual effective prosecutor made it more likely that Hunter Biden might have gotten in trouble. And then briefly on this, I mean, you guys keep saying that you've got a right to this information or that information. He offered to come and give you the information in testimony. And, you declined. Not only did he offer to do it, he did it in response to Chairman Comer's invitation to do it. Chairman Comer invited Hunter Biden to come September 13th, 2023. Hunter Biden's more than welcome to come in front of the committee. He's invited today. We will drop everything. On October 31st, 2023, Comer invited him again, saying, we're in the downhill phase of this investigation now because we have so many documents. We can bring these people in for depositions or hearings, whichever they choose. That's Chairman Comer's language. So, he took you up on the Oversight Committee chairman's language. You guys walked away from it after that. I think you might be nervous about what he might actually say. But that's the language of a statement who came from a committee chair whose name was on the subpoena. With that, I yield to my colleague from Pennsylvania.
I thank the gentleman. We're here today about trying to hold Hunter Biden in contempt for failing to respond to the subpoena. And of course, you've got everything upside down. Hunter Biden offered to testify right here under oath, and yet I'm now hearing from the other side of the aisle that would have been a staged event. Does that mean that every person you have called to testify here is just a staged event? Or are you actually trying to figure out facts and what has gone on? The majority on this committee is only interested in looking backward. And they only want to look backward so far. They only want to look at Hunter Biden. God forbid we would look at the former president and his family members who benefited personally from the president's position, who pocketed personally money during the administration, by the way. And yet I really refer you all to your own memo. This is supposed to be future looking. This is supposed to be how we craft legislation to deal with these issues. Read the first paragraph of page 3. Quote, the testimony sought by the subpoena is also relevant to ongoing efforts to craft legislative reforms to federal ethics and financial disclosure laws. The committees seek to craft legislative solutions that provide transparency when the president's or vice president's family members engage in lucrative financial transactions. As part of our investigation, the committees seek to craft legislative solutions aimed at the deficiencies we have identified in the current legal framework regarding ethics laws and the disclosure of financial interest related to the immediate family members of the vice presidents and presidents, deficiencies that may place American national security and interests at risk. Specifically, the committees are concerned that foreign nationals appear to have sought access and influence by engaging in lucrative business relationships with high-profile political figures, immediate family members. Doesn't that sound like that was drafted for Donald Trump and his family? It's future-looking. Let's craft legislation based on our recent experience with Donald Trump. I yield back.
Let me reclaim my time, and I ask for unanimous consent to enter the article debunking 4 viral rumors about the Bidens in Ukraine by Davey Alba, dated October 29, 2019.
Without objection.
I yield back.
Gentleman yields back. We're going to go to Mr. Bentz. Then
I just have a unanimous consent.
Unanimous consent, then?
I ask unanimous consent to put in the record a statement by myself and Mr. Schiff. And I'll just note that good luck on getting a prosecution for somebody who's been willing to testify, and I yield back.
Without objection. The gentleman from Oregon, and we'll try to, we got votes coming soon. We'll try to deal with this amendment, maybe one more. I know there's a couple more that the Democrats have. Gentleman's recognized.
I'll be brief, Mr. Chair, but thank you. And regarding Ms. Dean's amendment, I just want to remind folks, not that it'll do any good, to emphasize what this hearing is not, and it's not about the Kushners. It's not about what other people may have done. It's about the refusal of Mr. Hunter Biden to show up when he was subpoenaed for a deposition. That's what this is about. And so, of course, it's necessary to point out why he is an important witness, but that's not the issue before us today. The issue before us today is why did he choose to ignore a subpoena issued by this body? That's the issue before us today. And one of the things that's relevant is that does he have some sort of reason that would support his not showing up? And that's why I asked to be included in the record earlier the CRS report on the authority of this committee to decide how it wants to elicit evidence concerning the type of allegations that may ultimately lead to the president's impeachment. But that's not why we're here today. We're here today to ask the question, I suppose, why in the world didn't Mr. Hunter Biden show up when he was subpoenaed, as opposed to parading around in this building today, doing his best, I guess, to call out what he thinks is our inability to hold him to the law. He should be embarrassed. I'm sure he's not. But the point that we should be focusing upon is, are we enthusiastic about shoring up the power and authority of this committee to do its work? And if people are going to take this kind of opportunity to thwart the power of this committee, that should concern all of us, because the public expects us to do our best when we have evidence to try to get to the facts. And to that point again, Mr. Chair, I just want to go back to why a deposition is the right way to do this. First of all, it's how we generally approach things. Secondly, we have a set of rules that suggest this is the approach we should be using. And for us to do something other than take the deposition first and then bring the witness in front of this committee would be to fail the American people in how to appropriately get to the facts. Now, the folks on the other side of the aisle may say, and certainly have, as they try to distract from the real issue, that other people should be brought in, that we should expand our approach to including everybody. That's not what we're here for. We're here to try to figure out how in the world to address folks that spit in the eye of Congress, which is exactly what Hunter Biden is doing. He needs to be held accountable. I'm very happy for this hearing. I yield back.
Okay, gentleman yields back. The question occurs on the amendment from the gentlelady from Pennsylvania. The clerk will, all those in favor say aye.
Aye.
All those opposed, no. No. Opinion of the chairs, the noes have it. And a recorded vote has been requested. The clerk call the roll.
Mr. Jordan?
Nope.
Mr. Jordan votes no. Mr. Issa? No. Mr. Issa votes no.
You next.
Mr. Buck? Mr. Gates? Mr. Gates votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? No. Mr. Roy votes no. Mr. Bishop? No. Mr. Bishop votes no. Ms. Sparts? Ms. Sparts votes no. Mr. Fitzgerald? No. Mr. Fitzgerald votes no. Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Armstrong? No. Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? No. Mr. Van Drew votes no. Mr. Nels? No. Mr. Nels votes no. Mr. Moore? Mr. Kiley? Ms. Hageman? No. Ms. Hageman votes no. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse, Ms. McBath, Ms. Dean votes aye. Ms. Escobar, Ms. Ross votes aye. Ms. Bush, Mr. Ivy votes aye. Ms. Ballant votes aye.
Gentleman from Virginia.
Mr. Klein votes no.
Anyone else? Clerk will report.
Mr. Chairman, there are 9 ayes and 16 noes.
The amendment is not agreed to. The gentleman from New York is recognized for an amendment.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. The gentleman from Arizona reserves a point of order.
Amendment to the amendment in the nature of a substitute to the committee report for the
Without
resolution.
objection, the amendment will be considered as read. The gentleman from New York is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, the underlying report states that, quote, the committees are concerned that foreign nationals appear to have sought access and influence by engaging in lucrative business relationships with high-profile political figures, immediate family members, close quote. And it states that the committee seeks to craft legislative solutions to address this problem. My amendment provides further context for this discussion by highlighting recent reporting concerning former President Trump and the businesses controlled by his family during his presidency. Given the majority's interest in foreign nationals seeking access and influence through business relationships, I presume that they were alarmed to learn from recent reporting that properties owned by former President Donald Trump and controlled by his family during his presidency received at least $7.8 million in foreign payments from 20 countries during his tenure, including $5.5 million from the Chinese government and its state-controlled entities, as well as sizable payments from Saudi Arabia. The concern over foreign and domestic influence over the office of the president and other public officials is so critical an issue that the nation's founding fathers included bars to such entanglements in Articles 1 and 2 of the Constitution, known as the Emoluments Clauses. As the framers knew, even the appearance of corruption can lead to reasonable concerns that our democracy is for sale. Donald Trump has a long history of connecting his views of other nations to his financial remuneration, stating in 2015, for example, that he likes Saudi Arabia very much, since they buy apartments from him and spend in the tens of millions of dollars on these apartments. Recently, he's had warm words for China's leader, Xi Jinping, repeatedly calling him, quote, an exceptionally brilliant individual, close quote. Could it be because the Chinese government lined the pockets of his family business throughout his presidency? We don't know. But if the committee is truly interested in pursuing questions related to foreign influence of presidents by means of business relationships with family members, it would be a glaring hole to ignore the business relationships of the previous president and his family. My amendment would correct this deficiency. I ask that my colleagues support the amendment, and I yield back the balance of my time.
Withdraw. The gentleman withdraws his objection. The gentleman from Florida is recognized to speak on the amendment.
I'm glad that the ranking member has ripened the question of bribes from China. I think it's one that I would like to explore with Hunter Biden if he were willing to properly acknowledge and honor the subpoena that he'd received from the United States Congress. And if there's any comparison on the Trump policies toward China and the Biden policies toward China, I am eager to engage in that comparison because President Trump put tariffs on China. He was tougher on China than any Republican or Democrat president in my lifetime for sure. And what I've learned about studying bribes is that when people pay them, they typically want something in return. And so when you've got these allegations about Trump in China, you're able to easily compare that to a record where Trump cracked down on China. Now let's compare that to the Biden record. After the Biden China bribes, you get the Biden administration dissolving the China initiative that President Trump and his administration set up at DOJ to specifically go after and prosecute Chinese efforts to engage in malign influence with academia, with politicians, with high society. And I know we have members of this committee intimately familiar with Chinese malign influence. And we would want a DOJ resilient and capable to be able to ensure that no one fell victim to that, from the United States Congress to even service on a city council. Now, Hunter Biden had this interesting email exchange on his laptop related to China that I can't wait to ask him about when a judge ultimately orders him here or to a jail cell. Why was Hunter Biden hosting the annual meeting for his investment fund at the home of the Chinese ambassador? Seems like an odd choice. There are a lot of great venues in Washington that could host the meeting for your annual investment fund, but when you choose to do it at the home of the Chinese ambassador, that seems to send a pretty clear message that it's hard to figure out where China ends and the Bidens begin. And I found it particularly interesting that while Hunter Biden was personally setting up this special and unique venue to convince people to invest in his fund based on his close ties with the Chinese, that all he had to do to secure the venue was agree to a private one-on-one meeting with the ambassador beforehand, which the emails indicate Hunter was readily willing to do. So aren't the rest of you curious to know what the ambassador wanted to meet with Hunter Biden about before Hunter Biden used his Chinese relationships to enrich himself, his family, his relatives, his uncle, his father, to pay the bills, to run the Biden crime family? I'd like to know what was going on at that meeting.
Would the gentleman yield?
Sure.
Let me just say, it may very well be that what Hunter Biden was doing was wholly improper. It may very well be that what Hunter Biden was doing was criminal. There is a special prosecutor. What there isn't is any evidence that President Biden had anything to do with any of this.
Well, I would suggest that the ambassador from China probably wasn't requesting a one-on-one meeting with Hunter Biden to go over investment tips and investment strategies. And if we had Hunter Biden in the witness chair, we could ask him. So it's one thing to say, well, you know, there's just no evidence here. And then when we want to ask simple questions, like, was the ambassador asking about Hunter Biden's art interests and whether he preferred oil paintings or watercolors? I'm guessing that's not the case. And the reason Hunter Biden doesn't want to be in that witness chair is because when confronted with the documents and the evidence, they are boxed in, because everybody in this country knows what was going on. Hunter Biden was the bag man. He was collecting the money, and Joe Biden was the inside man, and he was delivering the results for China and anyone else that was willing to pay him off. And that's what we're trying to get to the bottom of. I yield back.
Gentleman yields. He seeks recognition. Question, gentleman from California.
I won't take the full 5 minutes, but I just want to sort of answer once and for all the absurd allegations about the former president. Not since George Washington have we likely had as wealthy a president as we did in President Donald Trump give up his day-to-day life as President Trump did. He gave up and put into trust 400 different entities, gave up control of them for his entire presidency. And for the Democrats to point to the sales that occurred at the Trump Hotel is not only beyond the pale, but it happens to be so factually incorrect with our founding fathers. During George Washington's presidency, were his thousands of acres simply laid fallow? Of course not. He continued to produce both wheat and grain, but also, as many know, alcohol. And he sold it. And he sold it to whoever bought it. And the buyer could well have been our own government. That was not the intent. And certainly, if his wheat or grain were exported and bought by some entity outside the U.S., nobody was going to say, oh my gosh, George Washington is on the pay of a foreign government. That's not what that clause in the Constitution means, and everyone knows it. But what it does mean is, did you receive funds, directly or indirectly, that were not for proper goods and services? That is what we believe Hunter Biden did. He received clearly millions of dollars into shadow companies, and there is little or no, in many cases, little or no actual performance, and certainly no history prior to the vice president having that position where Hunter Biden could go around the world selling it. But again, I'm going to just close. I said I'd make it in less than 5 minutes. We are not even talking about that, except that the Democrats want to keep making this about Donald Trump. It's not about Donald Trump or his family. If we had a subpoena to Donald Trump today or to his family and they wouldn't come, then I would be supporting a contempt until they did come. We have a valid, an undeniable subpoena that has not only been denied, but as I've said on every previous time, the middle finger has been pointed at the American people, and that is what we are here for today. I look forward to the vote and the final vote, and I yield back.
Gentleman yields back. Gentlelady from Pennsylvania.
I move to strike the last word.
Gentlelady is recognized.
I just want to correct the record, and that appears in the report that I have already put under unanimous consent into the record, the Democrats' report about the pocketing of millions of dollars over the course of 2 years of President Trump's term. I will note that once the Republicans came into the majority, now Chairman Comer shut down any more information coming to us about the other failures and taking of emoluments against the Constitution. But let's get the facts straight. Immediately, and I'm quoting the report, immediately after the 2016 election, ethics experts from across the political spectrum, reading the writing on the wall, urged the new president-elect to fully divest himself of his business interests and place them all in a truly independent blind trust. We all lived that. Guess what? It never happened. Again, quoting the report, throwing caution to the wind and the Constitution to the curb, former President Trump bluntly and cavalierly rejected all such bipartisan advice. Here's what he did. He instead chose to place the day-to-day management of his businesses in the hands of his 2 adult sons while retaining personal ownership and control of all his businesses, as well as the ability to draw funds from them without any outside disclosure. End quote. That's page 7 for those who want to begin to read the report. I'm not impressed that the former president did not take what he was constitutionally allowed to take, which was the president's salary. I am not impressed, because if you go to the report and you take a look at what happened, information, page 10 of the report, information available to the committee shows that among countries patronizing Trump properties, China made the largest total payments to the president's private business interests. Let's see who it was. According to the subset of documents obtained from Mazars and additional documents from the United States Securities and Exchange Commission, these payments collectively included millions of dollars from China's embassy in the United States, the Industrial and Commercial Bank of China, a Chinese state-owned enterprise, and Hainan Airline Holding Company, a subsidiary of Chinese company HNA Group, owned by the Hainan provincial government. And if you turn to page 14, the largest entry, there's a grid of all of the money that they were able to track by way of the financial documents. China's the top performer. Total spending through China to the president's entities identified, again, just 2 years and just partial documents, $5,572,548. Where were those dollars deposited, basically? Pocketed? Trump Tower, Trump International Hotel, Washington, D.C., Trump International Hotel, Las Vegas, $5.5 million taken in during the president's time when he failed to divest himself. I don't know about you, but once the president lost and had to leave the White House under terrible duress, as we all lived, did you notice what happened at Trump International Hotel? Closed. I yield back.
Generally yields back. The gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. Real quickly, this is raw politics, and the other side is real good at it. So, don't keep your eye on the ball. Look at the shiny object that we have over here. The shiny object is Donald Trump. But the fact is, that's not what this hearing is about. Now, we can talk about how Donald Trump made profits. that he was a businessman and a very successful one before he became president. When he made the profits while he was in the presidency, he donated those profits back to Treasury. We can talk about the fact that the Biden family has only and always made their money off of government. But the real issue at hand here is none of that. The real issue at hand is about Hunter Biden and Joe Biden and the relationship they had and the money that got filtered to the Biden family, that got filtered to Hunter because he was selling the presidency and the vice presidency. The real issue at hand is the fact that they made their money through the government and through influence peddling, and we want to find out more about that. What we're voting on today is not Donald Trump, it's none of it. But they want to have the public's eye on this other shiny object here. Let's keep the eye on the real issue, which is selling the United States government, which is selling foreign policy, which is doing the wrong thing. And Hunter and his dad were involved in it. We want to know more. And the last thing I'll say, you know, Americans know. Anybody else, when they're subpoenaed and have to do a deposition, they do the deposition from a legal authority like the Judiciary Committee. But Hunter, once again, thinks he's above everybody else, separated from everybody else, and more powerful from everybody else, and that's wrong. And Americans know that too. Let's vote on the damn matter at hand and not digress on all these other issues. I yield back. I yield to Andy Bigg. I yield to my colleague, Congressman Biggs.
Thank you. I appreciate that, Mr. Vandrew. So this is an interesting diversion, as you say. It is a diversionary tactic. The reality is Hunter Biden, $24 million, and that is just a portion of what's been reported. But they're not interested in that. Not interested in that. He defies the subpoena. Not interested in that. We're going to raise something else. And so they're going to raise something else that's actually very intriguing because what happened to President Trump is he transferred management and authority, but he also transferred titles to the trust. And when you transfer titles, that is an ownership transfer. You have to understand that, and contrary to what my colleague across the aisle said, from 400 affiliated entities. Now, the other thing that's really intriguing here is he was providing services, he's a magnate, he's got real estate holdings throughout the world. One of those holdings was in Manhattan. In 2008, Chinese company that my colleague just referenced entered into a contract to lease space. It wasn't some amorphous 20-some-odd shell corporations. It was a real entity providing real space, real value in exchange for money. That was in 2008. Let's see here. Oh, that was during Obama's term. It wasn't during Trump's term. It wasn't during his term. And so money that was paid in to that trust occurred during some of his time in office, but it went to the trust. But you're not going to hear that from the other side. They're going to argue this thing and try to make somehow a moral equivalency issue. And that's what's disgusting about this. Why don't they just admit Hunter Biden defied the subpoena? He willfully defied it. In fact, Mr. Ivey from Maryland told us earlier today, much earlier today, and this seems to extend. He said, yes, Hunter told us he wasn't going to come in. He willfully defied it. Guess what that means? You're in contempt of the subpoena you got. You don't get to say, hey, I'm going to come in when I want to come in, how I want to come in. You were given a date to come in, a time to come in, a location to come in, and you went out and held a press conference saying, I ain't going in. That is contempt. I yield back.
Gentleman yields back. The question occurs on the amendment offered by the gentleman from New York. All those in favor say aye.
Aye.
Those opposed, no.
No.
Opinion of the chairs, the noes have it. Roll call being, after the roll call, we will recess. I believe the minority has 2 more amendments, and we'll come back and deal with those and then vote on the final passage. But let's do this vote, and then we'll go vote on the floor.
Mr. Jordan?
Nope.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Buck? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Spartz? Ms. Spartz votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Mr. Moran votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Gates votes no.
Anyone else want to be recorded? Clerk will report.
Mr. Chairman, there are 9 ayes and 18 noes.
The amendment is not agreed to. The committee will stand in recess until the conclusion of this vote series and then come back for the finishing of the work for the day.